Welcome back, everybody. Happy Wednesday to all of you. It's hump day. It's a long week in the Karen Reed trial, but we are halfway through week three. Very on track, according to Judge Cannone. Right where we need to be time-wise, maybe even a little bit ahead of schedule. So getting now into the crux of the Commonwealth's case. We had the taillight plastic began to appear yesterday. And, this is really, from my perspective, the search is probably the worst fact that Karen has to deal with in the course of her defense, is trying to reconcile how is this taillight plastic there when her car hasn't been there since 12:30 the night before, roughly, and seems to match up to her car. How does that happen? It's a tough fact to explain. And so the timeline of the search has been a very important fact. It was in the first trial. It was in this trial. And so yesterday, when we heard from Lieutenant O'Hara, the first person to testify about the search, he described it as starting at about 5:20 or 5:25, something like that, when officers were first starting to arrive at the scene. And I remember thinking, that's not how I remember it from the first trial. I was pretty sure he said they waited for everybody to arrive and then they began their search. I was pretty sure that's what he said, but then I went back through my notes. I'm like, I don't see that here. Don't see that anywhere in my notes. So I dug into it a little bit. I had to go down this rabbit hole, and I'm going to share some of what is out there that I found with you guys this morning while we are waiting for old Judge Cannone to be ready to get court started. So I want to start with the trial testimony from 1.0 of Lieutenant O'Hara when he talks about them all arriving at the scene.
As far as this search was concerned, about how long a period of time was it that you were on scene as far as searching and how long the process was done?
Now, sorry for the sound being so bad, guys. Remember, it was really terrible last year. They have improved it this year. There was that lolly question. As far as the service was concerned, about how long a period of time was it after Lieutenant Tolley showed up, kind of informed us where we... he's going to start his answer now. How far is the service concerned? About how long a period of time was it?
After Lieutenant Tully showed up, kind of informed us where we were going to search. We moved Trooper Boussolet's vehicle at 5:20, and that's when the rest of the team started to show up, right around 5:21, 5:24. A couple other members with extended response time showed up a little bit after that, but all members were on scene by 5:41. We had already started the process before they had all arrived on scene, and we were complete by 6:15. We started to wrap up and clear the area.
So by 5:41, they had already started the process, is what he said last time. By 5:41, they had already started the process. So not necessarily how we remembered it. And they talked about, it was the same, very similar testimony, shoulder to shoulder search. And they started the process. It's very vague, isn't it? By 5:41, before then, they had started the process. But what process? The marking off the grid area, the actual process of doing the search, the securing the scene. It's not super clear what he was talking about in the first trial. But he did make that little comment they had started the process. Well, here's how it gets a little bit stickier. There is apparently a memo that went out. I'm going to share that with you guys next. There was an alert. Alert message. This is Sergeant Simpson. We are looking for members' availability to respond to Canton for evidence search involving the death of an off-duty Boston police officer. We do not have the green light yet. Just looking to establish a list of available members for when we are told to respond. Repeating, this is Sergeant Simpson. We are looking for members' availability to respond to Canton for evidence search involving the death of an off-duty Boston police officer. We do not have the green light yet, just looking to establish a list of available members for when we are told to respond. Here's the thing. This seems to be 533, but it's also a 23 year, this document is cut off. And so it's this really seems to be talking about John O'Keefe's death. But not entirely clear what this timestamp relates to. Doesn't seem to correspond with the day and time that we're expecting that to be sent. Doesn't correspond with the day of the search. So this is out there, but I'm not sure what it means. And I did check the witness list too to see, if this is a piece of evidence that could be helpful to the defense or even to the Commonwealth. O'Hara testified about the alert going out. He just said it was closer to like 2 something or 3 something. But he said they sent out the notice, told everybody they didn't have the green light yet, but checked on availability. Might be helpful to have Sergeant Simpson on the witness list to testify about this memo, but he's not on anybody's witness list. So I don't think this is coming in. I don't think that is going to help us solve the question of when exactly did all of this stuff happen. And so then there's one other thing that we found, thanks to Joe Flipperhead, who hangs out here sometimes. And that is that apparently this testimony that we heard yesterday from O'Hara, it seems to conflict with how Tully described this whole process happening. So let's go ahead and listen to that.
At some point, you respond to 34 Fairview Road. Is that correct?
Yes,
And do you recall about what time it was that you arrived there?
about 5:30 p.m.
And when you arrived there, who, if anyone else from the state police, preceded your arrival?
There was at least 2 members of the CERT team present, including Lieutenant O'Hara.
And
So he's not even there till 5:30, and there's only a couple of them there. Now, at least 2. Again, vague. At least 2, but not 7, 6, 5. At least 2. It's a bit vague, but at the very least, they couldn't start the search. They couldn't start any of the process, right? Until Tully was there to tell them where you're going. You don't even know. So you can't start any of the process. You can't start marking out the grid. You can't start moving the cars and clearing the area. You don't even know where you're supposed to be until after Tully gets there. And now Tully is saying he wasn't even there until 5:30. So it's a little bit of a mystery, all of this timeline of the search. Mystery does not benefit the Commonwealth. If the Commonwealth wants this to be a critical piece of their case, part of the facts and data that really establish why their theory of the accident, the incident, the death of John O'Keefe is the correct one, because Karen Reed's vehicle hadn't been at the scene since 12:30 the night before. So the only way her taillight could have been left there is if she had left it there at 12:30 the night before. There wasn't any opportunity before then for anybody to tamper with the crime scene, then you think you'd want to nail this down pretty specifically. So I am wondering, first off, is that why we saw a little bit greater specificity from Lieutenant O'Hara this time on the timeline of the search? Not just we started the process before the last member arrived at 5:41, which is after Karen Reed's car is in the Canton PD Sallyport. I get there about 5:30. To now, we definitely started the search as early back as like 5:20, 5:25. Definitely started the search as far back as then. We just added the stragglers, the last two to arrive when they arrived. Possible that's why he's getting more specific, because they want to try to nail down that fact and hammer that fact, which is really, one of the strongest ones they have, and possibly like the only strong one they have. But that's going to create a whole new set of problems, right? If Tully isn't going to be able to back that up, Tully's going to have to push it back, and we're going to be able to make Tully push it back at this point, because he said that at the first trial. Unless he's going to have an explanation for why he was wrong at the first trial and is now correcting his testimony, we're going to have to push it back, because they couldn't have started anything before Tully got there. They didn't even know where they were searching. So not until after 5:30 would they have even started marking out the grid, moving the cars, et cetera, et cetera. So that is a possible explanation for the new clarity that Lieutenant O'Hara provided yesterday about the timeline of that search. Another possibility, though, I gotta say, this came up yesterday, and I've seen a lot of people, wonder about this, because the presentation of this case by the Commonwealth, it seems very disjointed, very disorganized, very confusing, hard to follow. We're jumping around from time period to time period, and kind of getting different chunks of information before we move to something else, and then going back in and filling the gaps and stuff. Like, we haven't even heard the autopsy details yet. We know John is dead, but we've jumped way ahead now to the evening when they're doing a search, but we don't even have Karen's car in custody yet. So it's this very disjointed presentation, and folks are, I've heard folks wondering. We talked about it on the chat yesterday a little bit. Is he throwing this case? Is Brennan throwing this case? I don't think he's throwing the case. I don't think that's what he's doing, because he would have behaved differently in his pretrial conduct if he was throwing the case. The reality is most lawyers, they want to win. They want to win. They enjoy winning. Lawyers are competitive people, by and large, trial lawyers, certainly. So I really don't think he's throwing the case. But I did hear another theory that does intrigue me. I'm not quite sure I buy into it at this point. But it is maybe a little more consistent with what I'm seeing unfold. And that's the idea that he's not banking on a conviction. He knows the case is weak. He's not necessarily expecting to get the guilty verdict. So if he can't get the guilty verdict, the goal is to sow as much confusion as possible, which is not normally what the Commonwealth is going to do, right? Not normally what a prosecutor is going to do. They have the burden of proof. They're going to try to resolve as much confusion as they possibly can. But just the timeline alone from the Commonwealth, it really seems to be all over the place. If you're trying to track it, it's confusing. They're not presenting it in a clear and systematic way that's easy for the jury to understand. So why would they be trying to sow confusion? Well, because the best outcome they might all be hoping for at this point is the throwing up our hands, and we'll never know what happened. It's a mystery. It's too confusing. We can't sort it out. I guess we'll never know. And why would we do that? Because that benefits the folks involved in the cover-up. It protects the cover-up. Okay, we couldn't get Karen Reed convicted. There's reasonable doubt that Karen Reed did it, but we'll just never know what really happened. And quite frankly, in a certain sense, that might be the closest to the truth. No, we won't ever know. I think sometimes when we watch this trial, there's a hope and an expectation that we're going to get answers for all of this. We're going to find out exactly what happened, what's the truth. If John O'Keefe was beat up, and that's the solution, that's the answer, and it's what it looks like on his body. Who did it? How did it go down? How did they construct the cover-up? I think people really want these answers. I don't know that we're ever going to get them, guys. I know that that's disappointing, but that was the whole point. That was the whole point of, the fix. The no shit's going to come back on the homeowner because he's a Boston cop too. That's the whole point of the fix, is we're not going to get that evidence. We're not going to ask those questions. We're not going to enter that scene, those areas. We're not going to search. We're not going to check out the glassware. We're not going to do any of that. Specifically so we don't get the evidence, so that we'll never know. Worst case scenario, we never know. That's the point of calling in the favor with your buddy Lank, your buddy Proctor. All they need to know is take care of the situation. Help us manage this. We don't need specific instructions on how to do that, particularly Lank. Lank doesn't need specific instructions about how to help us manage this situation. He would know. Well, just don't look, don't ask. Do the minimum. Get the stories from the people in the house. Don't work too hard to corroborate them. Don't run the risk that they might come into conflict. Don't look too closely at the conflicts that you get in the statements. Remember one of the early interviews with Julie Albert? Julie Albert says she gets a phone call from Jen McCabe at like 5 a.m, and that's how she learned that John had died. Remember that? Just don't pay too much attention to conflicts like that normal investigators would absolutely identify and jump on and follow up on. Hey, these guys are telling different stories. He doesn't back up, the alibi, so to speak. We were all asleep in bed. We didn't know anything. If you knew at 5, you knew before Karen and Jen and Carrie got to the scene. So it's out there for them to know. They can notice, gee, he's got a big old head wound to the back of his head, but I don't see any blood. There's this part of a broken tumbler. And we snow blowered the whole area, leaf blew the whole area down to the bare grass, and we didn't find the rest of that tumbler. He's not dressed for the weather. He was supposed to be here. He was invited into this party. They were outside, but he never came in, they say. I think a normal investigator might follow up on that stuff. So all Lank needs to know is just
He's coming over. Why don't you come up to Sidebar?
Start with a sidebar. Like, I'm not even in a hurry to get it up on the screen at this point, because I know they're just going to go straight over to Sidebar. He doesn't need to be told specifically what your job is. He just needs to know, manage it. And before they know for sure that John is dead, particularly, it's going to be CPD that's the focus. It's going to be Link. Manage it. Don't look too close. Don't ask too many questions. Then once it gets handed off to MSP and it's in Proctor's hands, he doesn't need to be told specifically either. Just help us keep this under control. I think that's how a cover-up happens. Maybe Michael Proctor got a little over-inspired to help make sure the situation was managed. Haven't seen a lot of that yet, but once we get to those bumper sprinkles, becomes a lot more clear, because it's very hard to come up with a innocent explanation for that. Not sure that Michael Proctor knew that they'd be able to analyze the qualities of the glass and compare it to the tumbler that they found at the scene. See if it matched. I'm not sure he knew that they would be able to do that. But they did, and it doesn't match. So where did this glass come from? Where did the glass that they found on Karen's bumper after it was in the Canton Sally port? Where did that glass come from? So Proctor may have just gotten a little over exuberant with his role, but he certainly knew the assignment. Assignment's pinned on the girl. Make sure the homeowner doesn't get any shit, because he's a Boston cop too. He says the quiet part out loud. So that's how I think all of this unfolds. But the whole point of that is to make sure we'll never know. We don't get the evidence that you would need to get to be able to sort out what happened. We didn't challenge the witnesses at the scene. When you give me this inconsistent story about the timeline, Julie Albert's never challenged by the police. How did you know at 5 that he was dead when they never got to the scene until 6? Explain that, Julie. That never happened. So we never know how she would respond under fire like that. Higgins interviewed. Was he interviewed? Asked about the conflict. The conflict with John that's on that video. Asked about going back to Canton Police late at night. Hanging out there for how long? Got the key card. It's your police department. They never investigated any of that stuff. So unfortunately, time eliminates a lot of evidence and a lot of opportunities to be able to flesh that out. So I just think it's an unfortunate reality of this case that if Karen Reed is acquitted, I continue to think she probably will. Most likely outcome might still be a mistrial. Not quite sure where we're at on that right now. I'd have to think about it. But we have, massive amount of reasonable doubt. Defense has been pretty successfully countering everything that the Commonwealth has brought so far. Timing of the search, finding the plastic, really the worst fact that the defense has to deal with. But just look at the photos. Look at the photos. How are you finding plastic on top of several inches of compacted snow, when according to your own witness we just heard from, there shouldn't have been any snow on the ground really at all, just enough to track a cat. This should basically be at ground level if it happened when you said it did, and a lot of it isn't. Several of these photographs that you showed, they aren't. The shoe that you found, that is not covered up by the very small amount of snow that was present at the scene. And I mean, remember, it isn't just meadows. You know, we saw it clearly yesterday because of just the timing. They showed us meadows, and then, you know, while we're getting the snow report. So we can kind of put those two things together. He's saying 4 inches. Look at that Meadows driveway that we just saw. But we haven't just seen the Meadows driveway to gauge the snow. We've seen all this dash cam video. And, 4 inches of snow is about to the top of your shoes. About 4 inches of snow. And you can see people walking around in that street. It's not that much snow. It's getting compacted. It's blown off. They're really not sinking into the snow at all. We'll probably see the dash cam some more. If not, we can go back and check it. But just not an awful lot of snow there. So how did you not find that shoe earlier? Really seems like the kind of thing that you should have found there at the scene at the morning. It's big and bulky. It's not going to be completely covered by the snow. So even with this bad fact, a lot of questions about it. A lot of questions about it. Well, I am very eager to see where we go next. We're getting closer and closer to where just seems like if your story is going to be coherent, if your case is going to be coherent, if there's going to be like really any logic to it, it seems to be that we are going into the evidence collection part of the story, and then we'll get to the evidence analysis part of the story. Yes, we've been working our way through the precipient witnesses and the first responders and so forth. That seems to be the general order of the presentation. Well, that's going to get us, closer and closer to Proctor and Buchanan. So when are they going to be presented?
All right, can we bring the jurors in, Tony, please? Thank you.
You are unmuted.
And if that's the general structure of the Commonwealth's presentation, then we'll get the forensic stuff last. We'll get the accident reconstruction last. We'll get the autopsy. You know, all this stuff will be the lead up to the explanation for how this happened. I don't think the Commonwealth is going to call the rest of the folks in the house. I don't think they're going to. They're going to leave that to the defense. The defense wants to call Brian Albert, Brian Higgins, Nicole, Julie, all those folks. Matt McCabe. They might still call Julie Nagel. I think they got to call Julie Nagel. She's the one that quote unquote saw the black blob.
Okay, thank you.
Saw the black blob on the curb. But other than that, I don't think they're going to call the rest of the people in the house. They're going to leave that to the defense, which frankly is, maybe how Lally should have done it. You don't have to call every single witness just because they have information. If Jen McCabe knows all of the material stuff about what went on in the house, you can just rely on her. You don't have to call everybody. So I don't think they're going to. I think we're going to work our way through the rest of the law enforcement witnesses that are important. And that's probably primarily Lank, possibly Good, but I don't know that Good is critical. I don't remember Good having anything that really added to the other folks. And then we gotta get into the MSP guys. We gotta get into Proctor and Tully, Buchanan. Trooper Paul, are they going to call Trooper Paul? I kind of think they're not. Let the defense call him. And then a whole bunch of people from the lab, their accident reconstructionist and their medical examiner. Maybe they don't call her either. That's how I think the Commonwealth is getting done so much more quickly. That's how I think they're editing the case. They're just going to call a lot fewer people. And I think the people inside 34 Fairview are going to get the cut. Possibly some of the law enforcement will get the cut. I would expect most of the forensic folks, however, to make it in, because it's got to be important to substantiate the facts, science, and data that Mr. Brennan is quite sure that they have. I don't think he rests this week. I think it goes into next week. He had estimated 3 to 4 weeks to put on his case, and I think it'll be closer to 4. Is my expectation. Just given the number of folks they have left. Even if I try to think of how can we accelerate this as much as possible. Some of these witnesses will take more time than others. You know, obviously Proctor, probably Buchanan too, are going to take a fair amount of time. Tolley is probably going to take a fair amount of time. It took a long time last time with Maureen Hartnett and Ashley Valier, the people from the crime lab that did all the work with the Taillight, the pieces, the different testing of different things, just because of like the volume of everything. It took a while to get through them. And then there's still the DNA, the hair, you know, the testing, the black box, all of that stuff. I don't know if Tolley's going to try to do his cell site location with Karen's call records like he did last time. There was like this implication that she'd gone back to 34 Fairview before she went over to Jen McCabe's house, but they very much could not substantiate that. I don't know if they're going to try that again. But then, you know, they'll have a lot to get through with the accident reconstruction and all of that. So
I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
All right, thank you.
So no, I think this week would just not give them enough time. That would give them, you know, best case scenario. They've been getting through 4 or 5 witnesses a day, you know, 15 witnesses today, Thursday, and Friday. I don't think that's going to be enough. And I think some of these are going to take longer. So I would expect probably towards the end of next week. A very strange sound going on from the courtroom. Hum. I don't like it. Nothing I can do about it, though. It's like a fan is running or something.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannone, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
Connor Keefe, more cell phone extractions. I think this is a good point about Higgins. I don't know how much into the details, though, they want to go, and Higgins is a vulnerable witness. You know, they may think they can make the point that the relationship was crumbling just from Karen's text with John and the voice messages that she left. You don't necessarily need to get into the whole Higgins side of things. It's helpful from a smear standpoint. It doesn't make Karen look very good. But the trade-off is then, you know, Higgins gets cross-examined. And Higgins has got a lot of vulnerabilities, and it sounds like he may have more now because of the additional video that's been produced. So Connor Keefe is another one of the troopers who did cell phone extractions.
Raise your right hand. Thank you, Clark. Thank you.
Raise your right hand. You solemnly swear the evidence you give to the court and jury in the case now hearing should be truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning.
Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy,
How long was the academy?
approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes, in various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the district attorney's office.
Did you have a role in investigating this case?
Yes,
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved. Yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to Gray Key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence
He's the fall
found?
guy for
The
the chain of
CERT team
custody?
would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please.
Gonna look at some photos.
Trooper, do you recognize that item?
Yes,
What is it?
that is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you have gloves? Very important part of the theater here. Get your gloves and handle everything on the stand before you touch that piece of evidence.
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please.
He's
With the court's
actually got
permission,
some
I'm going to
blue
move this
nitrile
piece of
gloves.
evidence, item into evidence.
So guys, I know there was a lot of confusion last year about the shoe because the shoe in the photograph appears to have a
Let me
black
ask you a few questions
sole.
before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
And you will see that the shoe itself has a white sole. And so that came up a lot last year. People thought it was not the same shoe. Guys, this is not a indicator of like a shoe being planted. This is evidence of the terrible photography that they did at the scene. This is Trooper Tully not knowing anything at all about forensic photography and how to document. The photographs are terrible quality. It's a lighting issue. So don't be surprised when the shoe comes out of the bag and you see that it has a white sole. Oh yeah, handling those same old scissors. They've surely been sanitized since O'Hara handled them all
With the
yesterday,
court's
right?
permission, can he show the item?
Yes.
Reaching in and out through the bag, all over the outside of the bag. Do your Simba thing with the evidence.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag, I'd ask this to be marked as an exhibit.
All right, any objections to Yanetti?
There's no objection.
Mr. Yanetti will be doing the cross.
Exhibit 77.
77 is the
Sir,
shoe.
you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please.
Great documentation there. It could really be any time. Really, it just depends. You could write any time on the bag.
And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
Now let's run our dirty hands back all over this item. least he's using what appear to be sterile gloves. Oh, I take it back. Second on Google. Only if it's specifically packaged. AI says blue latex gloves are more commonly used for general medical exams or procedures where a high degree of sterility isn't required. Sterile gloves are individually wrapped to maintain their sterility throughout the process of sterilization, transportation, storage, and use. So not just things that you stuff into your pocket after you pulled them out of a box with, 50 other items.
Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the
Oh,
jury as
God.
well?
Why not? There's no chain of custody to it. We don't know how it ended up in the bag.
Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Don't know how this got in.
Okay.
Yeah, there's going to be a chain of custody objection to this, I would expect. It hasn't been established. Certainly not as to that third piece of plastic. We haven't seen it documented at the scene. We have no record of who put it in the bag or how it even got in the bag. This is going to be a very interesting cross-examination. Based on Connor Keefe's testimony, should be his name on the bag, should be, his signature. He's the one that's entering the times, the dates, and so forth. It should be entered into evidence by him. So the evidence log should start with him, being the first person to possess this and booking it into evidence. Surely the Commonwealth will show us that if that's the case, right? They haven't so far. They might come back to it.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, in the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. I'd like you to safely secure it, bring it with you, and bag it when you leave.
Yes, sir.
Bag it
And
separately.
I'd like to introduce that exhibit.
Take it out. Take it out and now admit
So we're
it.
going to mark the little chip.
You want-
Mr.
you'd like to mark
Yanetti
it?
asked to
Okay.
mark that.
Yes, you need to mark
Yes.
that and keep
And we're going
that
to submit
in
that for
the
identification.
courthouse.
So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
It is not
you
leaving
very
the
much.
courthouse.
Exhibit 78.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have exhibit 73, please? Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you
Oh, sure. We
bag
can
that
see with
item?
our own eyes.
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
Oh, this is going to be fire. He's the one that drew the
I'm showing you
short
a photo.
straw
You recognize what's in it?
on the chain of custody problems.
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay. There's no objection, Mr. Yanetti?
There's no objection, no.
Exhibit 79.
Yeah,
With
this is the
permission, could we
question.
show exhibit 79 to the jury?
Yes.
Saw him like an inch of snow. Don't think we mean ground
Still would be able
level
to close-
the
thank you.
same.
You recognize that item, sir?
Yes.
Camera
Did you bring
dude.
those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
He's not going to show us the screen, so we can't see what this photo was. Sometimes these camera people really suck. They did slip, right? Consistent with what you saw that morning. What morning? What morning? When was he out there in the morning? He wasn't out there in the morning, but he didn't correct him.
Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Great question. Why haven't they marked these items and used that to conduct their photography? That would
Thank you,
certainly be
Trooper.
the normal way. You would
I'd
document
move these
a
items
search
as
like
evidence.
this.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Mr. Yanetti?
Please, Your Honor, thank you.
Get some water real
Good
quickly.
morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes. He's nervous. Oh, a little sniff. Check that out, little sniff. He's
Now, I
not
just
sure
ask you to
what's
read
coming.
that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct, 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the,
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation, no.
You have not yet.
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
okay.
Sniffs, man. What's with the sniffs? Is that the nervous tick you guys have in Massachusetts? Ooh, and now a little like horse blowing out their breath through their lips.
You do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
To an
May I
extent.
approach you on it?
Yes.
Very qualified, very evasive. Well, it might refresh me just to the extent of whatever you stick under my nose. I'll concede it. I do actually understand this. It's pine pollen is the bright yellow stuff that gets all over everything. It's from evergreens. It's actually too large to cause allergies. You're not getting allergies from that. You might be getting it from other things that are coming into bloom or grass that's going to seed and stuff like that. But we get the yellow too. We get the yellow too. The thing is that allergies make your nose run. And so if you're sniffing, it's going to be wet. These are not like wet sniffs. These are very sharp, dry intakes of breath.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done.
Read it all. Jim McCabe style. Turning a little red there, a little tight in the face.
And Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take
Sure,
a look, sir.
go ahead.
Oh, you just like to refresh about the whole thing. Let me see that. Just let me see that.
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
Okay. And the two of you would have participated in that interview together, correct?
yes,
But you did not write the report, correct?
no, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. May I approach, Judge?
Yes.
Thank you. You're welcome.
That tight face at the jury.
Other other examples are the reports on the videos that well, strike that. Let me start by saying this. Asking you this. You retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach.
Okay.
A lot of beaker faces on these cops.
Sorry.
He's got that same beaker face as Gallagher had. Like,
Read that silently to yourself and look up at me when you're done.
Upside down smile, big frown, big deep frown. I don't know what this hand wringing is now, too. Guys, all I really get out of body language generally is you can see anxiety, you can see discomfort. Just looks like a fair amount of anxiety to me. It's normal to be nervous about being a witness. Probably less so when you're a cop and you do it all the time. But of course, if you're just there to tell the truth, there's nothing to be nervous about. Crack some knuckles there.
Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. Right. I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And by the way,
You're stuck.
I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
This is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes. Again, I only got a copy of the surveillance video.
Sure.
I did not do any analysis.
And with regard to the waterfall,
You didn't count the drinks.
That was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Okay.
I'd have to see that one as well.
Another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
Bev doesn't know the relevance, I'm guessing, so they're going up to the stand to explain the relevance. I guess DeChico gets referred to in a particular way. This is an interesting setup. He's tying Proctor to the analysis of the surveillance videos. This was something that I remember from the last trial. Proctor wrote very specific times, and he signed affidavits to this effect as well, where he observed Karen taking drinks, putting additional shots into her glass, and so on and so forth. But he didn't testify to any of that in the first trial. They had Yuri Buchanan do it instead. They played the video late in the afternoon, went through and narrated the drinks. And we're watching this paying close attention, unlike everybody else in the courtroom. And we're not seeing what he's describing happen. So they are tying this much more closely to Buchanan, or to Proctor
In terms
this time.
of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
It
You
depends.
attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office
The medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Ask it differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment.
He doesn't remember a detail like John's injuries. It seems pretty important to the investigation. He's got to look at the report for that. I don't think this guy is starting to come across as very credible.
Approach, Your Honor?
You shouldn't need to be reminded of what his injuries were, and you shouldn't be so resistant to it.
You want this one back?
Oh, please, thank you.
I mean, the injuries are the one thing you should have down pat.
Document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done.
I love this expression.
And I would
He's
direct
back to
your
his
attention the
beaker
second
face.
page for the question I just asked you.
Back to that very tight, frowny beaker face.
Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
That's what the paper says?
Yes.
Gonna do a McCabe? No,
Now,
okay.
is this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, When the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of questioning.
Sustained.
May we approach?
Okay.
He wrote it. He's there watching
Feel
as
free to
she's
stand up.
verbally describing what she sees. How the autopsy usually works. They have a note taker, or they have a recording, and they verbally describe what they are seeing as they are observing it. So he would know. He would know what she's seeing. She's calling it out. The objection on this is speculation or just outside of his personal knowledge. He doesn't know what Scorti-Bello saw, but he would if she is saying, I'm seeing this while he's there present in the autopsy room. I would also note this is well beyond the scope of the direct examination. So it does appear that Judge Bev is not being real strict about, no, your examination is limited to just the subjects that are raised on direct. And if you want to go into other topics, you have to recall him in your case in chief. That is not a very efficient way to proceed. So most judges will do away with that. The notable exception to that was Judge Gull back in Indiana in the Richard Allen trial. Very, very formal on limiting the cross-examination to the subjects raised on direct. And if you wanted to go further, they were going to have to recall all of those witnesses. Do you wonder if we're going to get to these bags and the plastic that appeared and whose name is on the bag and when did it get booked into evidence and by whom and all that? When did the chain of custody start?
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
It's the same thing, just ask a different.
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
the body.
I'm sorry?
She was looking at the body, I assume.
Thank you. Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scorti-Bello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
Not getting to the bag.
Thank you.
All right, you're all set, Trooper.
Thank you.
So, jurors, this break we're going to take now.
We're going to take a break.
All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next half hour, maybe. I want counsel
Half
to
hour.
All right, to the court, please.
That means it'll be an hour. Not sure why we're breaking to do some stuff with the lawyers right now, but we'll see. Are they going to do it all at Sidebar, or will we get to see? Well, I thought David Yanetti did a great job of coming back from those objections and making them look ridiculous. He was obviously allowed to continue with the general line of questioning and lay his foundation. And he's able to point out, like, they're trying to keep me from being able to tell you that her eyes were on the body. No, she wasn't looking at the ceiling.
So I want to talk a little bit more about what we talked about at Sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A. And that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor.
Got a certified copy.
Yeah, approach.
Yes.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor, and the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
On one area, right? One specific area?
Well, you can call it.
On the decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
Give you the answer, Your Honor. I will explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp. She is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Tried to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance to materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location. And although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case, nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp.
No, that was raised, but this. what was problematic in Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been advertised with regard to Apple source codes. And if I could, Your Honor.
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertize, to use a term to suggest some type of conclusion that has no basis in fact, is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact.
That's a little over the top.
Case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data stats. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term galvanize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, in any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint, she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point.
I don't agree with that.
This has nothing to do with her opinion whatsoever. It's just an
I don't agree
attempt to
with
try
that.
to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate
It is,
decision.
Your Honor. It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started. And that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, She has no peer-reviewed article to say that how she is determining that that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
Right, and Mr. Alessi, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, or your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls, but if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm
So
not
you
being
use it then?
presumptuous, although there was a offer of proof earlier on similar evidence, but not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
But I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here?
Your Honor, may I ask one thing? May I, Mr. Gray?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Well, it sounds like that's a solution. How many times have we had to hold the defense experts over or have them make special trips to come here to decide issues? She can stay another day. She can stay another day. Oh man, this is such good lawyering by Alessi. We're gonna go back through this and break this down when we get a chance. Boy, he does his homework. He really does his homework. This is exactly what you want to see a lawyer do. You have evidence you want to get in. You go through the rules and you figure out your pathway, and you do that ahead of time. You do that in advance as part of your prep. So he already knows he wants this in. What's the pathway? It's Rule 39A, dealing with the records from other states. It shall come in. Oh, shall is wonderful. It is mandatory language. It means she doesn't have discretion. So her reliability, the way he's framed this, she was found to be unreliable in another court. Her methodology was found to be unreliable in another court. So it wasn't allowed to be presented. It's at least some of it almost exactly the same thing, but even the part that isn't the same thing, dealing with location data and so forth, it's subject to the same reasoning. And so, yeah, that's classic impeachment. But another court found that your testimony wasn't sufficiently reliable for the jury to hear it. But you're saying it's reliable in this case. You're showing the point, the counterpoint. So yeah, I would expect that to be allowed. And frankly, even if it isn't exactly the same methodology, in that case, it probably would go to credibility.
Goodbye.
Well, I guess we're going to a longer break now. Let me go ahead and get the fan off the screen here and the thing muted. Even if it's not, if you're found by another court, you're an expert. Your job is to go in and testify and present evidence that's helpful. And another court finds you're in here offering stuff that's unreliable. Is that impeachable? Yeah, I think it should be. And the point that he's making, redirect it. If it's that bad, if it's that remote, then the prosecutor is going to be able to come back on redirect and be like, Ms. Hyde, that thing that was found to be unreliable, you didn't do that same process in this case, did you? And so there's been no finding that this process that you're testifying about to this jury is unreliable. And you can just, manage that. If it's that remote. The way that he has constitutionalized the issue, as he should, is very appropriate. This goes to her right to confront the witness. Her right to confront the witness on material that may bear on the weight that the jury should give her opinion. If she's been found to be unreliable, does that affect the weight you might give her opinion? Yeah, it might. Yeah, it might. And so then the Commonwealth can come back. If they don't think it's a big deal, they can explain why they don't think it's a big deal. But that's what cross-examination is all about. So I love everything about this. He did his homework. He found the case. He investigated the pathway. He found it in the rules. Got that good, strong language, the mandatory admission, not discretionary. The only way that it gets excluded is if it's irrelevant. So she has to find that a court in another jurisdiction finding that Jessica Hyde doing this stuff is irrelevant or more prejudicial than probative? Not just more, but substantially more prejudicial than probative? That seems pretty tough. Seems pretty tough when her reliability, is a central issue when she's an expert in the case. So it's not irrelevant. Is it substantially more prejudicial than probative? How can it be when you can just go in and redirect her? Just go in on redirect and explain. You think this is unrelated. You think this is a different methodology. You think it doesn't have any bearing on her reliability as an expert, her methodologies. You can explain that on your redirect. I don't know how you get to substantially more prejudicial than probative to justify keeping this out. So quite a good argument there from Mr. Alessi. I enjoyed that very much. There's some very, very good lawyering, in my opinion. Don't know, of course, what ruling we're going to get. Apparently, judge is going to take her time and have to think about it. Are we going to sit here for half an hour while she decides? I'm not entirely sure. So much for that half hour she told the jury was going to take. Apparently, it's going to take a little bit longer than that. Maybe she's just taking the rest of her morning recess before the jury comes back and Jessica Hyde will stay here overnight. Don't know. We got to wait and see. I don't know why we deal with scheduling at Sidebar. Is that so secretive and sensitive that it needs to be kept from the public? Because it seems to be pretty important to me after you've made the defense witnesses, put aside their other work, file the report when you want it filed, show up for voir dires when you want them to show up. And I didn't hear Brennan say anything about how she can't stay overnight. Okay, she can't stay till Friday, so you can call her tomorrow. I think we should understand the basis for different treatment if there is going to be different treatment. So why would we be handling the situation differently? Defense doesn't yet know which expert they're going to call for their cell phone forensics. That's very interesting. So they might not use Richard Green. They might use somebody else. The Brennan objection here, it really is over the top, isn't it? It comes across as one of those confession by projection things. They're just going to dehumanize her. Why? By pointing out she's been wrong before is somehow dehumanizing. Well, you're sitting there trying to play these clips of Karen and trying to, make her look like an awful person because she did that imitation of Peggy O'Keefe. Leaning over the bar, he looked like he was hit by a car. Really? They're the ones trying to dehumanize the witnesses? Please. Please. Well, boy, not a lot done today from a substantive standpoint so far. Couple little notes I made, little stars I put by points that came up during Connor Keefe's testimony. He believes the photos were time-stamped. The photos that Tully took, those non-forensic, very poor quality, doesn't know how to deal with light, doesn't know how to deal with perspective, doesn't know how to, go from the wide to the fine. No evidence markers, as one of you guys pointed out in chat. So typically when you're doing a search like this, a search of an area, what you're doing is the crime scene folks are going through, and when they find a piece, when they find something that's evident, they place a marker. and everything stays in its location until you have gone through and you found everything and you've marked everything, and then you document the scene. You document this whole process. I mean, you show it as it's happening, but then you have an overall view. Take it from lots of different angles, from different perspectives. Here is all the evidence in relationship to each other, in relationship to the scene as a whole. And then you go in, once all of that documentation has been done, you go in and you take the evidence and you secure it and you bag it and you, place it into evidence. So that's like the normal process you'd expect from a crime scene investigation. Clearly not what happened here. And the photography, not what you would expect. Not what you would expect from a forensic standpoint. Nevertheless, this comment, he believes the photos were time-stamped. I mean, once again, we're back to this issue of, why aren't you showing me? If that's the case and the photos were time-stamped, show it, Commonwealth, because now you've just kind of raised an issue I hadn't really thought about before. But these could be faked, or they could be, later. Part of the whole timeline with the search is, well, they started, finding plastic, and Karen's SUV was like barely in the Sally port and so forth. What if they found the plastic and these photos are taken at they're all taken in a clump at like 6:14, 6:13, 6:10 even? I mean, it goes to the timeline, right? You had to find these early because you did your very careful excavation for another 7 or 8 feet and found nothing. And that took some time, line by line. I thought about this too. They're kind of layer by layer, removal of the snow. And by this point, I think we heard they've gotten like 20 inches of snow? 16, 14, I don't know. Let's go back and look. Let's go back and look at what the weatherman said yesterday. Twelve and a half inches total as of noon. And then total accumulation was 23.8 or something like that. 23.8 inches, the vast majority of which came well after 6 a.m. That was from Alessi's cross-examination. 22 and a half by 6 p.m. So that's when the search team is out there, 22 and a half. So think about this for a second. How many layers, how many inches are the layers that they're going through with the snow? Okay, even if it's, say, 4 inches at a time, 6 inches at a time that we're going through layer by layer looking for evidence, that means it's taking you like 4 times in each area to get down to ground level. If you're doing 4 inches at a time to get through 24 inches of snow, it's going to take you about 6 separate shovel and turn over and sift and expose and all of that before you get to ground level. And you're doing this, of course, line by line across this entire area that has been described. I think that gives me, I think, a little better perspective on the time that it would have taken to do that. That would have taken some time. So that brings me back to the timestamp on the photos. It should have been early, right? It should have been early in the search process. Why haven't we seen the timestamps? If they support your theory of the case, why wouldn't you bring them in? Same thing with the writing on the bag and the evidence and so forth. The fact they have to take an unknown piece of plastic with no provenance out of the evidence bag in order to get the evidence bag into evidence. Do you think that caught the jury's attention at all? That certainly caught mine. Oh, this doesn't belong in here. The sealed item that we've just been going through all of this theater with in front of you. Told you about how we seal things and initial and reseal and log it in and keep it secure. But there's this unknown thing we can't explain. So we're just going to take it out. We're just going to take it out here and put the rest in. Pretend like it wasn't there at all. Certainly caught my attention. Did that catch the jury's attention, do you think? This piece doesn't belong in there? I think they're asking themselves some questions about where did that come from and how did it get in that bag, and why aren't you explaining where did that piece come from and how it got in that bag? If this just cracked off one of the other pieces, why don't you show me that? Show me, just, put them together. Show me where it came from. The Commonwealth has the burden of proof. So you can't just put it out there as maybe it's like this. No, maybe isn't proof beyond a reasonable doubt. The jury's going to specifically be told maybe is not satisfying the burden of proof. If you think maybe she did it, no. Even if you think probably she did it, it's not enough. That's not proof beyond a reasonable doubt. So maybe it broke off one of the other pieces. Prove it. Show me that. It shouldn't be difficult to do because it's like a puzzle piece, right? They match right back up together. You should be able to do that. And if not, where did this piece come from? And why wasn't it carefully tracked by these highly trained and careful investigators? Definitely caught my attention. Got to take it out of the bag. Same thing then with the bag with a second piece in it. There's a photo of it. There's a photo of this second piece. We heard that the photos are time-stamped, but we hadn't heard anything about this during Lieutenant O'Hara's investigation. So, okay, there's a photo of it. Is that photo from the time of the search? We don't know. It's just a photo, is kind of all we were told. So was this collected at the same time and you just overlooked it when you had O'Hara on the stand and it got bagged together at the same time? We don't know. If the photo is time-stamped, seems like we'd be able to figure that out. So why aren't we seeing the timestamp that you made a point of raising? You can get from these photos. So we only heard about one clear piece during O'Hara's examination, and it was that diffuser piece, the one with the distinct markings that we recognized. But now suddenly in this bag there's two, but there's a photo of it, but we don't know when the photo is from. But the photo is time-stamped, but you're not showing us the timestamp. It's very bizarre. It's very bizarre. Connor Keefe is his name, the one that's on these evidence bags. That's something we can double check because those evidence bags are in evidence from the last trial. In fact, I might be able to find that from maybe Sleuthy Goosey's timeline, perhaps. I know she had the evidence at one point. Trial exhibits and witness lists. Here they are. Okay. Let me just see if I can find this. See a few evidence packages. I'm just going through to look and see if we can see anything with Connor Keefe's name on it. Not seeing anything so far. Yeah, see, here's okay, this is, you guys can't see what I'm looking at, so I haven't shared it yet. But I'm just kind of going fairly systematically through evidence packages that I can find. Here's what I remember. Let me share this with you guys. Here's what I remember. Okay. This is what it looked like when they showed many of the evidence bags in the first trial. They were these close-up photos, okay, broken red glass. We see the this is the evidence, you know, one of the evidence stickers from when it's booked in, but look at the date, 2/4. 2/4. DMD, I believe this is David DeCicco, who has you know, gotten the seal on this one. So that's definitely how I remember some of this evidence being shown. Here's another one, it looks like. Here's another one on the bag. This is clear plastic. Once again, DMD looks like David DeCicco, but it's 2/4. That's the date, not 129. Not 129. And as I recall, I'm just going to go through all of them and double check. Here's the red. More of the red plastic. More red plastic, 2/4, David DeCicco. This is how this stuff was admitted into evidence in the first trial. And so it got a little bit unclear with that cert search. Now then things start to change. We get a little deeper into the evidence. Here's a bag where you can see this is the evidence bag. Date of collection 2/10. Collected by Sergeant Buchanan, 14 pieces of glass and plastic fragments. This is when they start doing the drive-bys. Pretty sure it was Tully, if not Tully, then Proctor, who made the decision that we're not going to continue with a cert and bring cert back. We're just going to tell the officers to drive by the house on their way to work in the morning and just look and see if you find anything. And so lo and behold, over the coming weeks, as the snow melts, is the story. The glass and plastic begin to appear. They reveal themselves, and they're collected and taken into evidence. So here, strangely, we have this part of the evidence bag is in evidence, the part from, with the writing on it. We can see who is taking responsibility for this collection and noting the date and the time of it and what's in it. It was Sergeant Buchanan on 2/10, but we didn't see any of that for the cert search. just a little strange. Here's another one. Check this one out. Check this one out. 2-8, collected by Trooper Proctor at approximately noon. A large piece, taillight, a large piece of red plastic, a small piece of red plastic, piece of black plastic, found on the front lawn of 34 Fairview. We can see all of this on the evidence bag, the ones that were done after the fact. But the ones from the search, I don't think they put that real closely into evidence for us. Very next day, February 11th, here's 3 more pieces of clear and 5 more pieces of red collected by Trooper Proctor. We can all see it very clearly. Oh, hey, check this out. 3-9-22. Huh. Wonder what that's about. Collected on 2-11-22. 3-9-22 is when this is logged into evidence. Huh. Peculiar. So all this stuff is still to come. And I'm not sure. I'm not sure what we're going to get here. I'm not sure what we're going to get. Is Connor Keefe's name on these bags? And that's why he had to be the fall guy for it? Wasn't booked into evidence, and it has Trooper DeChico's initials on the tape on 2-4. Why would we be sealing it on 2-4 if you collected it on 129? And you said your job was to collect it, seal it, and get it into evidence, document it. But we don't have anything in evidence showing that that's what happened. Not from the last trial. Here's another one. 2-18. Several pieces of clear and red plastic from Trooper Proctor from 34 Fairview Road. That's the only location we get by this point. We don't know if it's in the road or if it's in the grass. Just 34 Fairview Road. Guess it doesn't matter. Not important to the reconstruction. Any photographs of any of these pieces when and as they were found? I'll let you guess. Not that came into evidence in the last trial. So, not sure we have any other pieces of plastic that came in evidence bags. I think that's about it. So just notice that discrepancy between the way that some of this stuff is presented. Now here's an intriguing evidence bag. Let's look at this one. DeChico on 2-3, broken red and clear plastic, front of 34 Fairview Road in Canton, found at 10 o'clock on 2-3. Is this the one that we're seeing the tape? It would make sense for Trooper DeChico to have sealed this one up. It would make sense for him to have sealed this one up and put his initials on it because he's the one that collected it, and it was just the day before. Why didn't he do it the same day? That wouldn't be so clear. But at least we're in the ballpark. So were those first ones not from the search at all? Why aren't there evidence bags in evidence from the first trial that document these cert pieces that have Connor Keefe's name on them? Here's another one from Trooper Proctor. Let's bring that one up. I'm just going through these very systematically from the timeline, from the last trial. You can see all the exhibit numbers changing. 2-8-22 at 11:30, collected by Trooper Proctor, several pieces of red and clear plastic. Yet another one by Proctor. Where's Where's one for Keefe? Hey, guess what? That's all. That's all of the photos of the evidence bags that were admitted last time. That's it. Where's Connor Keefe? Where's January 29th? Where is his bag, his initials, the tape? I mean, once again, the Commonwealth is who has the burden of proof. You're handling the evidence bags right there, having him cut them open and so on and so forth. Did you just verify? His name is on the bag. You collected it. You dated it. Here's your name. Here's the date. Here's the description of what you collected. Here's the seal. Here's your initials on the seal. Here's the evidence tag showing that it was booked into evidence when you collected it. You have the burden of proof to show that this is all reliable. The chain of custody is intact. So why haven't you done that? I do wonder if we're going to get more. I do wonder if we're going to get more of this. I'm just not sure. I'm not sure. Obviously, the defense didn't raise it either. Defense isn't who has the burden of proof. It's the Commonwealth. So if this all supports your theory and the validity of your investigation, wouldn't you call it out, especially given that there seem to be some issues, some discrepancies with what's in the bag and what's supposed to be in the bag? $12:08 on 2/22 was the time that the consent to search the phone was signed and noted by both Jen McCabe and Connor Keefe. That was elicited on cross. Not entirely sure why. We didn't get a connection drawn. Does that conflict with Jen McCabe's testimony about when she handed her phone over? Not sure I remember that. Let me go back and check through the notes of her testimony. Okay, a lot of notes for Jen because she started her direct on day 6 and it continued into day 7 and then cross continued into day 8. She was pretty extensive. Let's see. So we finished day 6 at the scene, right? I remember that. So then we went into day 7 with the 911 call and so forth. Next day, she went to Meadows. They wanted to take the phone. Interesting. Okay, so she was shown the consent form on direct, at the very end of direct, and AJ had objected to it being introduced. There was a sidebar, and apparently AJ won whatever objection that was because it didn't come into evidence when Brennan tried to offer in her consent form. I don't know what that's about. She didn't give a specific time or anything like that. She didn't even give a date in her direct exam, at least. She didn't even give a date for when she handed her phone over. There seems to be something up with the consent form, guys. I don't know what it is. The defense was able to get their copy in, but Brennan wasn't able to get his in. This is I don't know what this is about, but it means something. It means something. I'm just not quite sure what it means. Not quite sure what it means. And if it's like a contrast between the documents, maybe, okay, here's a hypothetical. The one that Mr. Brennan was trying to introduce, ostensibly the original, doesn't have a time written on it. Something like that. So then instead the copy comes in where the time is written on it. Could be something like that, but then wouldn't you want both in so that you can show the compare and contrast? How obviously this document was changed after the fact? Something like that. I mean, it's a possible explanation, but we don't have a way of knowing because that original form wasn't put in. There seems to be something going on with the consent form, guys, and I'm not sure what it was, but it definitely caught my attention. Mr. Yanetti specifically elicited that the date and the time that the consent form was signed, got the consent form, the copy of the original into evidence, and then didn't take it any further. And I'm not sure why, but it means something. Great job of avoiding the semantic game that the Commonwealth played in the last trial, where I'm going to bring the stream back up, even though they're not quite doing anything yet. But I just want to be ready to go back quickly. I'm seeing words come up on the screen, so there's some kind of conversation happening in the court, but they're not calling it back into session yet. Last trial, they played the semantic game over lead investigator and case agent. Very distancing Proctor from lead investigator. No, he was the case agent, and so really he was a coordinator. He just coordinated things, but it's really a group effort, a team effort. So trying to take the responsibility out of Trooper Proctor's hands and kind of diffuse it. And so by the same token, trying to minimize the effect of his misconduct. Okay, maybe he was a bad guy, but other people had equal input into and control over the investigation. It was just, he was just a coordinator. It didn't taint everything. And they've already kind of gotten out in front of that, haven't they? With Connor Keefe, he's admitted, yeah, it was Proctor's case. He was the lead investigator there. A lead investigator is assigned. That's pretty typical. It was his case. Pin it on him. Pin it on him. It's a very good correction from the last time. Connor Keefe comes across as so evasive. You gotta be reminded about a lot of stuff. Got to be reminded about a lot of stuff. You don't remember the injuries on John's nose when you were at the autopsy? You're going to need to see the report to be reminded of that. The quibbling over we don't give input, we provide the facts of the case, that is input. Yeah, that's input. How do you argue with that being input? I thought Yanetti handled that very well too. He's just bemused. Oh, okay. Well, if that word doesn't work for you, you provided her information. And that just highlights that this is a strange defensiveness that you're demonstrating. It's not substantive. At best, it's semantic. And Why? We're saying the same thing. So why are you being so unnecessarily difficult, quibbling over input? That was very well handled. Then into that argument from Mr. Alessi about Jessica Hyde. So just to restate and clarify what he's trying to do, he's trying to admit into evidence a Superior Court ruling from a Maryland case from March of this year, where she tried to present some information that seems to have something to do with location data and her cell phone analysis. And it was not allowed. It was found to be unreliable. And in part, that's because, according to the opinion, they say she doesn't have the Apple source code. So she doesn't actually know. That's part of the problem here. So he wants to be able to bring that up when he is cross-examining her about the fact that, another court found that your method was unreliable and wouldn't allow you to testify to it because you didn't have access to the Apple source code. So you don't actually know. You're using these proxies to do the evaluation, but those are basically speculative. They're not reliable. It has kind of crossed my mind. Okay, somebody might wonder, why doesn't somebody just subpoena Apple's source code? Why doesn't somebody just subpoena Apple's source code and then they have it? Something that has happened in the past, for example, with Apple, it's happened. The part that jumped into my mind was the ancestry databases, the genetic genealogy stuff. People voluntarily submit their DNA into these databases because they're conducting ancestry research. They want to know about potential health conditions that they have, just curiosity. Get a lot of different information from doing that. So some of these databases, extremely large, not all of them afford law enforcement access to be able to go in and search. And law enforcement wants access to as much DNA as possible because they use that for their investigative genetic genealogy research. The more profiles they can get access to, just the better chance they have of being able to match whatever their profile of interest is with a person or a relative in the database. And so there have been cases because these databases don't provide law enforcement access to everything. It's an opt-in situation. It's an opt-in status. You have to specifically say, yes, it's okay for law enforcement to use my data. Otherwise, they can't access it. And so what they've done is they've gone and gotten search warrants for it, for the stuff that they're not allowed to have. And that's been upheld. So there have been cases where, that was allowed to be subpoenaed. And then, you've just kind of worked around that restriction on not being able to access it. So could you do a similar thing with Apple's source code? So Apple's source code is going to be a trade secret. It's proprietary information, like they pointed out. So as a trade secret, it does get some protection under the law, but not absolute protection. And frankly, not sure I see a big distinction between the genetic profiles that a DNA company, a private DNA company, stores in their own database for the use of their customers and their clients for specific purposes. Is that not proprietary information? I mean, maybe it isn't. I don't know, but kind of seems like it is. I mean, it's developed through their own process. The way that most of these databases work is there's a kit for a consumer. There's a kit. You go in and you do your cheek swab. You mail it in. They develop the profile. They put it into their database. They compare it with the other profiles. You get a report, information, and so forth. So it seems like a lot of that is at least pretty close to proprietary information. Wouldn't that be the same thing? Trade secrets are not absolutely protected, but it's a situation where, say, I sent them a subpoena, they would probably move to quash it. And the whole point of a trade secret is that it's necessary for your business competitiveness. If your competitors got access to all of this information, it would hurt your business, basically. So you're entitled to keep some things secret. But the thing is that there's ways to protect that from happening. There's ways to protect that from happening. You can have a protective order, right? This will be provided, but it will be kept confidential. It will not be redisclosed. Limited to access to a certain number of people. It's just, I wonder, has anybody ever tried that? And if so, why not? Just go try to get the source code. It'd be, it'd be very helpful. It's probably going to get quite a bit of protection as a trade secret, but just not seeing that there's a broad confidentiality protection for Apple source code that would overcome legitimate law enforcement interests. Now you're going to typically have to show, I need it. I need it for this case. I have a special need. Well, if we have this massive dispute over 227 and what it means and where it came from and how it came about and stuff like that, the source code would sure help solve that. I don't know, just kind of a thought I had, but I'm not in the habit of subpoenaing trade secrets, so not necessarily sure exactly how that would play out. I'm sure that they would challenge it, but would there be sufficient protections they could put into place if there's a high need for it? And there's no other way to answer your question than to evaluate the source code? I don't know. Would be interested to see somebody try that. Well, I'm going to go ahead and take the chance to start going through some comments and questions. Caitlin, 1980s baby. Good morning, Andrea and chat. Day 11. Here we go. We are off. We are off and running, and we've hit a little bit of a bump in the road, haven't we? Here on Hump Day, we have hit the road bump. Sitting here waiting for Judge Cannone to decide, is she going to be forced to let Alessi do this cross-examination? He's really boxed her in well, I think, between the rule, the mandatory language of the rule, the right to cross-examination, and the fact that the cure, if the Commonwealth doesn't like it, is to redirect. You think it's stupid? Show the jury why it's stupid. We'll see what she comes up with. Bino, hi, Andrea, checking in from Ireland again. Shout out, please, to my bro-in-law, Kirko Ward, who is recovering well in hospital. Well, that is great to hear. Sorry to hear that you're in the hospital at all, Kirko Ward. But glad to hear that you're on the mend. Thank you so much for that. And thanks for being here from Ireland. Oh, it looks like they're coming back.
The meeting as an attendee and will be muted throughout the meeting.
Please be seated, court is in session.
The host would like you to unmute your microphone. You can.
All right. I appreciate the time. I appreciate people's patience. So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So
she had to go look for other stuff to try to justify, and she literally relies on the policy statement. That's weak. That is very weak.
Chrissy, do you want this under
specific
that?
rule will control over a general rule that talks about the same thing. That's one of the principles of statutory construction, the specific general rule. There is a specific rule that he cited that's dealing with the admission of records from other courts. That is going to control over how generally should we interpret and apply these rules as a matter of policy. This is like a statement of policy. Like, yeah, trials should be efficient. And but that fairness part, are you reading that out? Reading that out of the rule? The specific rule is generally going to be the one that applies over the general over the general one. So if the general one says maybe, maybe not, but a specific one says yes, then the answer is yes. Is it appealable? Yeah, I think it is. I think it is. But the fact that she had to go do her own independent research to try to find a reason to keep this out, it just shows you the incentive, the motive. She had to go look for a reason to keep it out. She wants to keep it out.
Put it back in session. You may be seated.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan.
The Commonwealth calls Jessica Hyde.
Didn't make her wait overnight and spend an extra day. Didn't interpret those rules to promote simplicity and elimination of delay when it came to ARCA voir dires, Dr. Russell voir dires, Richard Green voir dires, did we?
This way. Follow that answer right there.
Follow me, please.
Yes, he is definitely allowed to cross about the methodology.
You solemnly swear the evidence given to the court and jury in the case now and here and the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space HYDE.
What do you do for a living?
I'm a digital forensics examiner. I'm also an an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
She is so out of breath.
In addition to
Nervous?
teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University, not
sorry.
Georgetown, but thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work
If they
been peer
provided
reviewed
it.
in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. on local time here in Norfolk on January 29th, 2022 from the device I was provided, yes. Not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or
so we're back to there were Google searches then?
I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 time frame. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually three, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran two different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns the Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual. And on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup. And I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the gray key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted, or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
When you use the term artifact, what does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo, any action.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Ha's Long to Die in Cold. However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So Ha's Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab, or you can open a new tab. A new tab was opened at 2:27 a.m., and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is How's Long to Die in the Cold, because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Trying to use her hands to make this point, but I'm not sure she's making it clearer. And she hasn't said this in a way that is really helpful. The tab was opened at 2:27, and that search was done there. The How's Long to Die in Cold. That was easy to understand, but I'm not sure that's what she wanted us to think.
Table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the that will help you explain?
It will.
I move this to evidence.
Who are you from, or have that bit of jacket if you want.
So far we are bolstering Ian Whiffen. It's kind of ironic, isn't it, that we just heard about how the rules are to be construed to secure simplicity and elimination of delay, and that doesn't allow cross, but it allows this witness to come in and testify about the same stuff as Ian Whiffen, that is duplicative. Just interesting little construction there. The ironies in this case never cease to entertain. So much of what she has done is so far, it's very confusing. It's very technical. I don't think the jury is following this necessarily. And so I think the question is going to be like, are they just overwhelmed enough to think, well, she's an expert because she's using all these big words and talking about these processes and identifying these specific things like EXIF tool and PYF PDF script and stuff like that. It's possible they've just tuned out some of the details by now. The challenge of that, though, is that when you do say things in simple lay terms for them to understand, they may latch on to that. And so when you say things like, there were searches at the 227, what was searched at 227? And it's kind of this confused explanation with the browser states. But one thing that was clear was the tab was opened at 227 and that search was done there. Which search? The How's Long search. That's a risk. The jury is just seizing on the parts that we can kind of understand. The other tab that was moved to background contained It's Raining Men. This was a little bit confusing when Ian Whiffen did it too, trying to sort out, like, do we have a timeline of phone activity that correlates to these actions that could just spell it out and make it clear what your opinion is? Because I just don't think that they've done that real directly to this point. Maybe they're going to, and that's part of what she's done, and that they're trying to get introduced here. But notice also how very limited the scope of what she was asked to do was. Just looking at certain time frames, certain deletions, Safari searches, and phone calls. So, when she says things like, oh, an action may create an artifact, it doesn't necessarily, okay, but it might, a user action. And then once you get the extraction, it contains the record of these various user interactions based on the artifacts that they do or don't produce. And so specifically outside the scope of what she was asked to do is any analysis of artifacts in the phone that might relate to a different time frame, such as the time frame between January 29th and the How's Long to Die in Cold stuff and February 2nd, when this extraction she says was done. So now we've got our timeline narrowed. That relates back to the consent form, it seems like. So the PDF was created at 5:45. That was 2 hours and 45 minutes after the image started. So that means the image started roughly at 3:04. 3 hours after the consent was received. Is that the window that we're looking at, that we're trying to highlight? I'm not sure. Not sure if that's where we're going. It may be. Why wouldn't you take the phone and just plug it in? Maybe they were doing carries first. I don't know. But just kind of anticipating how these pieces that have been fed to us today may be fitting together. So yeah, I think the biggest thing that Ms. David has to look out for is not burying the jury in so much technical language that when she states things in lay terms, they stand out. And if she's going to do that, they better say exactly what she means for them to say. Because that could be all the jury comes away with.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart or no?
Why don't I just ask you?
See if you can answer the questions and if you can first.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search, how long to die in cold?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I used Sanderson's Forensics Toolkit. The forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also used Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used Artex and Mushy. But the, I'm sorry, ArtX is capital A, lowercase rt, capital E, lowercase x, and then Mushy is M-U-S-H-Y. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Cellebrite, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Cellebrite tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Cellebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How's Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out, went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
And so I want to talk about
Is that a yes or no then?
But I want to get back to the 227 search.
It's reported it or not.
So when you produced or you looked at the report for Celebrite and it showed this timestamp as well as the phrase, how's long to die in the cold, where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when the search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the knowledge CDB. The knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question yet.
Okay. Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 2:27:40 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 6:23 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair, understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those, and I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for browser state DB, cloud tabs artifacts, history DB, mobile Safari plist, knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 6:23:51, did you look into how long TIDIE in CIKD? So
that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in knowledge C and one is in the mobile Safari plist.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the knowledge CDB, what Apple's trying to learn about you, as well as in that mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD, CIKLD, CIKD, CIKD.
And finally, at 6:24:47, did you identify any artifacts with that search that appears with the timestamp of 2/27/40, did you find the same?
Correct. At 6:24, we have 2 timestamps in the same 2 locations for Hoslong to die in cold. The Knowledge C and the Mobile Safari PLS.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "house long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "house long to die in cold" was searched at that timestamp tab of 2:27:40?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at Sidebar, Mr. Alessi.
Thank you, Your Honor.
And what is your opinion? He needs to narrow the scope. He needs to be more targeted, I think, is what's going on here. Having a sidebar. I mean, is this too much? Is this too much for the jury? You know, throwing in all of these different things, multiple databases. Here's what Knowledge C is about: SQLite and parsing versus carving. Are we getting lost in the details here? If the jury is trying to follow this, are they getting lost in these details? I'm taking a lot of this down in my notes, and you know, I can understand generally, because this is, of course, now the second or third time we've seen it after the first trial. But of course, this is duplicative of Ian Whiffen, the rules on securing the efficient and you know, minimize delay considerations for the rules apparently don't apply to presenting evidence about Hoslong to die in cold, only to cross-examining about Hoslong to die in cold. I'm going to talk a little bit more about that when we get to the break, and why I think that particular ruling is a problem, why I think it's an issue. Talked a little bit about the general specific rule of interpretation so far, but well, if she's going to give me the chance, I'll just get into it. Rules of interpretation only come up when the statute or the rule that you're interpreting is ambiguous. The language is unclear. It's not clear what the rule means. Not does the rule apply to this situation or not apply to this situation. So when she's citing this rule that talks about how the rules are to be construed, what that means that this rule covers is, if you're looking somewhere else in the rules of criminal procedure and it says something and you don't know what it means, the language is facially ambiguous and you need to interpret it, then you apply this, you know, this principle of statutory construction. You're going to apply other principles of statutory statutory interpretation that come through case law. But this is going to be a policy that guides your decision about what does this statute actually mean. So step number 1, I got to find this statute is ambiguous. It's unclear. It's not, it's a language problem with the rule. The rule that Mr. Alessi cited, there doesn't seem to be a language problem. It's pretty crystal clear. It says, you shall let it in. You shall. It's competent and admissible. So that's not ambiguous. That's not a problem understanding what the words mean. That's you trying to find a reason why this rule is inapplicable. That's not what Rule 2 is for. It's not saying ignore the rules if applying them would make the case take longer. That's not what Rule 2 is about. It's about, if you need help understanding what this rule actually means, because the language is unclear for some reason, then you apply this this principle. You adopt the interpretation that tends to promote, it'll be a more efficient trial, it'll reduce delay, etc. So what's the ambiguity that we're dealing with that requires the rule that Mr. Alessi cited to be construed? Construed is a term of art. It means that we don't know what this means. We don't know what this language means. So in Washington, I deal with a lot of appeals dealing with what does the rule mean? And the way that we address this here in Washington, there's a difference between interpretation and construction. So interpretation is where we are looking at this to determine, is this ambiguous at all? And so we're looking at, is the language unclear? We'll go to the dictionary. We will look at the context of the statute as a whole to see, does it make sense? Are these words used in other parts of the statute? Does that help us understand these words? And so if that makes it clear at that point, we don't proceed to statutory construction. Statutory construction is when we've decided it's unclear. And so now we need to look at things like what's the legislative history of the statute? What are the policies governing how the statute should be interpreted? What are the rules, the canons of construction that are applied to determine what this statute means? You only do that after you've looked at the plain language and decided, I can't say what this rule means just by looking at the language. That's what construction is. It's looking to outside context to help you understand an ambiguous term. One of those statutory canons of construction, by the way, the rule of lenity. The rule of lenity in criminal cases means that when a statute is ambiguous, you must adopt the interpretation that favors the defendant. You give them the benefit of the doubt because part of the point of having rules and statutes in the first place, rule of law, basic rule of law stuff, is to give people notice. So if it's unclear what it means, people aren't on notice. So you interpret it in favor of the defendant. That's one of the canons of construction as well. As she read Rule 2, in construing this statute, you shall make sure that it, furthers these specific goals and so on and so forth. That's statutory construction. You don't get there until you've already decided. Secure simplicity, fairness, and elimination of delay. You don't get there till you've already decided the words don't make sense. I can't make sense of the words. So I need to look at policy to understand the words. Something unclear about the words? Shall be admitted? Shall be admitted? There's nothing unclear about that. That is very clear. It is. There's going to be abundant case law. I haven't looked at Massachusetts. Not recently anyway, not that I remember off the top of my head. But I'd be shocked if they don't have abundant case law saying that when a rule or a statute says shall, that creates a mandatory obligation, no discretion. When it says may, that creates discretion on the part of the court. It's not obligatory. Nothing unclear about this language. So relying on Rule 2, that's not what Rule 2 is about or for.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analysts?
That doesn't answer the
This
question.
methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual
so
testing and
unresponsive.
creation of data sets. And I was also a part of the subcommittee that drafted that.
You didn't
So
ask
I'm
for your
intimately
resume.
familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How
Sure.
about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the
He's not asking
specific
for your
guidance
resume.
regarding searching
Asking for the
different
validation of the
databases for
method.
artifacts?
In terms of methodology for digging into databases,
Yes.
is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology.
There are multiple books on digital forensics, many of which I've read, and including books
Be more
specifically
specific.
on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions. Is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's long to die in cold" was made at the time of the timestamp 2/27/40?
It's the last time, Mr. Alessi, on this issue, okay?
Last time, that's a nice little comment there from the judge. That's inappropriate. That's inappropriate. That's putting your thumb on the scale there right in front of the jury. Last time, Mr. Alessi. Bev is she done okay with me the first couple days of this week. But now she's reverting back into her putting the thumb on the scale. First with that terrible ruling that doesn't seem to appreciate what statutory construction actually is that this rule is applying to. And now with the little comment in front of the jury, don't waste my time anymore, Mr. Alessi, is basically what she's saying. Did she not just communicate to the jury, you're wasting my time? You're wasting my time with the objections, but the Commonwealth presenting duplicative evidence about the 2:27 a.m. search, not wasting anybody's time. You know, it's not appropriate for the attorneys to make their editorial comments. It's not appropriate for the judge either. Very inappropriate for the judge to be communicating their opinion about the defense raising objections. Now, what happens if he has to object again? She said this is the last time. What if he needs to object again? Have another sidebar. Then what? The jury's already been told, well, this is a waste of time. Just as inappropriate, if not perhaps more so, than for the attorneys to make their editorial comments, because the judge, of course, is supposed to be impartial and above the fray, and not communicating their own opinion about what's coming out in the process and the weight that it should be given, the attention they should be paying, et cetera, et cetera. Very inappropriate for a judge to do that. And in fact, the jury is going to be instructed. They might have been instructed in the preliminary instructions. It's the attorney's duty to raise objections, and you're to draw no inference from it. Whether they objected, whether it was sustained or overruled, these are just technical issues that relate to what is admissible under the rules of evidence and what isn't. They're supposed to draw no inference from it, but here you are communicating that you don't think much of this objection. Last time, that was a little over the line, Judge. Not having the best day, Judge Cannone. Not having the best day now, having to search out independently her own reason to justify trying to keep out this this impeachment evidence, and coming up with nothing better than a rule that applies to statutory construction, which does not appear to be necessary for the authority that Mr. Alessi has presented.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 2:27:40 was, whether or not that was the time the search "How long to die in the cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, "How long to die in the cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion, to a degree of scientific certainty, whether there was any other searches similar to how long to die in the cold that evening on that tab?
Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
You have an
thought.
opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6:24:47, how's long to die in cold?
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Oh, interesting. So she
Did
can't say
you
it wasn't
develop
also
a chart
searched at
that I
227.
mentioned earlier?
Yes.
Like to approach?
Yes.
Interesting.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior redactions, I would object to that.
Okay, I'm going to allow this into evidence. Your right to say it. Mr.
Thank you,
President.
Your Honor, appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
Come on, camera guy. We don't want to stare at her in the dark.
Could we enlarge the
Show us
first two?
the table.
And we're going to need to get the right column in if we can, please. Thank you. Ms. Hyde, can you see it from there?
I can. Thank you.
If you can walk us through
Yep,
how
this is the
this
key right here.
exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says, how's long to die in cold? How do I understand your opinion that that search didn't happen at 2:27:40?
She didn't
This
say that.
document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term how's long to die in cold, with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides the artifact, the cache record.
Mm-hmm.
What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, This is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the Mobile Safari P-list, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see how long to die in cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that how long, HOS long to die in cold was searched at 6:24:18, tracked in that Mobile Safari P-list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the how long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
The time.
To a reasonable degree of certainty, I can say that How's Long to Die in Cold was searched at approximately 6:24 a.m.
Now, moving on from the 2:27 search, there are 2 other issues that you were asked to analyze.
And then he just
We
undid
talked
it with
about
the
at
2:27
beginning.
search.
Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, how long to die in cold, was user deleted on that device.
So there's 2 really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that dash wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common. When that database stores data, it has 2 versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant.
Please don't.
And
Could you
we're
stop?
sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table.
Let's not.
The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. The waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those WAL files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table
That's not
yet.
the current state.
So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back.
No,
waffles and pancakes
not
haven't
right.
come out yet.
Look,
So when we get
I
the
feel pretty
data,
bright.
we get two files. We get
I'm
the
not following
restaurant,
this.
that's the database, and we get the serving area, that's the WAL file. Just because it's in the WAL file does not mean it's deleted. It means that that record wasn't where it naturally sits yet.
But it could mean
be
it's deleted because you said it goes back.
that WAL file can contain deleteds and food or data that hasn't yet been delivered to the database. So the WAL file consists of both. So an assumption that the data was deleted just because it's in the WAL file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in the statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the WAL file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the WAL file. That particular item is a little bit more complex, actually exists on multiple pages
Don't make it
because
more
it
complex.
moves as the database is being created,
Don't
but
make it more
all of them
complex.
have the same unique identifier. So it's the same entry. It's not more than one search of Haas Long to Die in Cold. If there was more than one search that had occurred where it became the top element in that database, we would see
Can we
that.
have a new question somewhere in here?
There are,
Break up the narrative.
as I mentioned, other carved from the database, from the WAL file elements such as the search for the YouTube video, It's Raining Men. Because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Haas Long to Die in Cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the WAL file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the WAL file for that reason. That doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you
write a
could clear the
program that would
cache, for
delete the
example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you
Like an
can't
app?
delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web, that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parse. So every tool chooses to do that differently. That does not mean deleted. It means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the dataset generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count too, and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all in the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining is recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days,
So
but on
first
this
in,
device,
first
we do
out.
see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
So do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
So
Can I
then
see
it would
Counselor
be
Sidebar regarding scheduling and a few things?
consistent, first in, first out, right? They wouldn't be selectively deleted. But I'm not sure that's what we see from the call log, is it? I'm not quite sure we see that from the call log. Boy, if only we had somebody that tracked the call log. Yeah, let's see here. A little bit of a yeah. Not real clear. Not real clear. If her testimony is correct, then every phone call before 8:59 a.m. should be deleted. There shouldn't be a single call record in her phone from before 8:59 a.m. on January the 29th. Wonder if that's going to hold up. We're obviously going to go to lunch before we get the cross-examination from Mr. Alessi. This, I don't know how the jury was able to follow this. If the jury was able to follow this, She got through that whole series of questioning the objections that Mr. Alessi was raising to the methodology, the lack of stating of her methodology without stating a methodology. She provided her resume. I took classes is not a methodology. I took classes is not a methodology.
All right, Ms. Hyde, I'm going to let the jurors have lunch. You can walk out after.
Thank you.
Lunch too.
Thank you, Your Honor.
45 minutes.
Thank you, Your
Jurors
Honor.
will recess for 45 minutes.
All rise for the court, please. Here's close your notebooks, follow me.
So we'll be back in the ballpark of my local time here. Will be about 10:35 if we get a 45-minute lunch. Assume nothing's going to happen in court, but I'll just mute it and leave it on in case they come back for some reason. She went through all that and just provided her resume. I'm sorry, there are papers and I took classes. Do not establish a methodology. And then, my goodness, that narrative answer. She said specifically her opinion. She cannot say with any scientific degree of certainty what happened in that tab before the 624 search for Haas Long. She can't say with certainty. That was specifically the opinion that she offered. Did you notice that slimy little question that Mr. Brennan then slipped in? It didn't get objected to. It should have. Facts not in evidence. Where he asked her, how does this support your opinion that the search didn't happen at 227? She specifically disclaimed having an opinion about whether the search happened at 227 because she said she can't speak to the history of that tab. She can't say with any certainty. All she can say is there was a search at 624. But she can't say what happened on the tab before that. She did not actually opine that there was no search at 227. But he slipped that into the question. Did she explain that to the satisfaction of the jury? I was losing it. Why are we even talking about a wall file? It's so unclear. It's so clear, and she never explained a wall file is what is the same thing as the write-ahead log that I'm talking about. Maybe they're able to make that leap, but they just might be lost about what are we talking about and what do waffles have to do with any of it? What do they have to do with any of it? So I'll be interested to see if the phone record substantiates. There should not be a single call log in that phone from before 8:59 on January the 29th, or her explanation is not correct because she's given a first in, first out type of explanation for why these calls show as deleted, but not deleted by the user. Something that the system does automatically because of its storage capacity. It reaches storage capacity, it deletes the oldest call. Is that the only source, the only reason why these calls are identified as deleted? I don't know. Did Celebrite update that too? I don't know. Looking forward to this cross-exam by Mr. Alessi and seeing where we get. See where we get with it. Well, guys, let's continue with some questions and comments before I take my little break. You guys know the routine. You know the routine. The main thing is the trees right now. You saw yesterday, it took me probably 20 to 25 minutes to get the trees good and thoroughly watered. It's a time-consuming process. What can I tell you? They're the most demanding pets I've ever had. So just want to make sure we have enough time to get the trees taken care of. Summertime, in my opinion, the investigation was so botched, the state can't prove that anything happened at this scene whatsoever. New to the case, was JOK even murdered? Well, that's the $1 million question. At the outset, That's not what they argued. They originally arrested her for manslaughter. And I think the general understanding or expectation was that this was an accident. She was drunk. It just happened. Nobody intended for John to die, which is that's what murder is. It's intent. It's an intent crime, and you intend a specific outcome, which is the death of the victim. Nobody was arguing that initially. It wasn't until, Karen didn't take a plea deal. Then they went back to the grand jury and they upgraded the charges all the way up to second-degree murder, which is what we're facing now. And they've had to come up with these various theories about why is this a murder? How do we know this is a murder? What's the motive anyway? Had that reach at the last trial that had something to do with Aruba the month before. The general idea seems to be that they were breaking up and she was mad and they had a fight. So that's the motive. That's the explanation, rather than let your loser boyfriend, as she called him on the phone, you're a loser, John. Called him in that voice message, rather than just letting the loser go be a loser with someone else. She murdered him. That's the theory. I agree with you. This investigation is super botched, and I don't know. I don't know how you can rely on it for much of anything. James Casatelli, the McAlberts may never see legal justice, but they'll also never live a peaceful life again. Jen McCabe will never be queen bee again. You know, the whole issue with the accusation, it taints someone forever. You can never undo it. Remember Johnny Depp saying that in Depp versus Heard. You know, once Amber Heard decided to make that decision, his life is forever different. And you hear that a lot of times with, exoneration cases, people that were falsely accused, they've been exonerated. It doesn't matter. The taint of the accusation follows them forever. And there will always be people that insist that they did it anyway. We see this with cases that, frankly, from an evidence standpoint, should be pretty clear that the conviction was wrongful, like Amanda Knox, like the Central Park Five. Dig into the evidentiary grounds for these convictions in the first place and the reason why they were exonerated. Pretty substantiated by the evidence that they did not do it. But there will always be people that believe they did. You can't change that. Well, the same thing kind of happens in reverse, doesn't it? If you've put somebody on blast as a potential third-party suspect, it's going to stick. It's going to stick. That is the power of accusation. So, situation is what it is now. The rural juror, if the Commonwealth doesn't bring the Bryans and the defense doesn't that just make them look even more shady? Not as shady as not calling Proctor, but maybe. I think it just depends on, is the defense able to elicit anything kind of material and independent from these witnesses that would provide a reason why the Commonwealth should have called them in addition to Jen? You know, do they have information? Like, they don't have to call everybody that was in the house to confirm, John didn't come in. They really don't have to do that. They can rely on Jen. They can rely on Sarah Levinson. They don't have to call all the friends that appeared, all the friends that were at the party and stuff. Now, Lally did all this the first time, but it's not necessary. It can be duplicative unless they have something new and different to add. So I think that would be the challenge here. If the defense can show there's something new and different for them to add, then yeah, you might wonder, well, why didn't the Commonwealth call them? If it's just to impeach them, to challenge them, then maybe not so clear. I mean, certainly the Commonwealth isn't going to elicit their shady behavior. So I guess the question is, does leaving that for the defense to bring out all of the butt dials, all those communications, the SIM card in the dumpster, on the military base, out of the phone, etc. Does it make the Commonwealth look shady for not bringing that in? No, it might, yeah. If you expect the Commonwealth to be presenting the whole story, including the stuff that doesn't help them, then yeah, that's going to look shady. Let's see. Oh, I got to take my banner down here. We're at lunch. Let's go ahead and put that one up. Amanda Lang, if there was only enough snow to track a cat when John fell, wouldn't there be a nice clear outline of bare ground for law enforcement to see where he'd lain? That is certainly what you'd expect. Yeah. That is very much what you'd expect. There would be a significant differential between the amount of snow that is covering the area where John laid, assuming there's some time gap between John is picked up and put on the stretcher and taken into the ambulance, and the snow is still falling at this point. It's going to fall on the area where John laid. It's going to start to accumulate, but differential between that and the snow that's already there. So I would think you would notice that. Oh, there's a 1/2 inch to 1 inch of snow in this part, but there's 4.5 to 5 inches of snow everywhere else. Yeah, I would think you would notice that. There would be a very clear outline, and that it isn't present in any of the pictures. Nobody's described it. That's not what the situation was. The rural juror, as a nurse, the way he is holding his hands as if standing at an OR table is sending me, you're not sterile, dude. Oh, the guy with his gloves. His blue gloves that he pulled out of his very sterile pocket, I'm sure. Very sterile pocket that those gloves were in. Meanwhile, Yanetti is salivating at defense table about the demonstration Hank just did of this poor investigation. Yeah, let's just take this piece of taillight out of the bag. That'll solve the problem. We won't ask why it was in there in the first place, how it got there, who put it there. We won't ask any of those questions. We'll just take it out of this bag. That was a highlight, wasn't it? All right, guys, I am going to go ahead and take my quick break here. Go out and check everything. So I'm going to step aside for just a moment. Thank you guys for hanging tight. I will be back shortly. I'll go ahead and try a little different music for you guys this time. I've been using some, just for some variation. I don't know what all these are, but give you something new. So just so I don't jump scare you when I come back. All right, guys, be back in a minute. Okay, guys, we are back. Thank you for hanging tight with me. Trees are great. Trees are great. They're not in the mood they were in yesterday, even though it's like exactly the same outside. I have no explanation. I just have to give them what they want when they want it. And I don't get to ask why. Why today? Why not yesterday? No questions. No questions about any of that. Well, I did see something over the break that I'm going to go ahead and share with you guys. Let me go ahead and get it lined up in a way that will be helpful for us to be able to look at. So Brandy Churchwell, she's at Brandy in Church on Twitter. She has found the Maryland decision that involved Jessica Hyde. So we're going to go ahead and see that. So let me go ahead and pull it up. Take myself. That's probably small enough. So here is the decision. Let's digest this together. I haven't read this yet. So Ms. Hyde testified that her personal real-world scenario testis was a basis for her opinion that the methodology in the case is reliable. Okay, she did that here. She testified that while she did not conduct new testing on this guy's device, she used her notes and her data set from her personal testing. However, in Mr. Blank's case, the phone in question was an iPhone 6S running 15.7.2 iOS with no SIM card, had not been wiped of pre-existing data, and was not jailbroken. The phones are not the same model, the operating systems are not the same, and with the exception of neither phone having a SIM card, the other settings are not identical. Notably absent was testimony as to similarities or parallels that exist between the iPhone 6S and 7 models, which would explain yielding the same test result. She did not testify as to any similarities or parallels between the operating systems 15.7.2 and 15.8, which would explain why testing would yield the same results. Okay. Not necessarily an issue in this case, other than I have to observe she didn't testify. She just said she did testing. She didn't provide any detail at all about the testing that she did, what she did it on. Don't think it was on Jen McCabe's phone itself. She's testified her models leave the data unchanged. Handling Jen's actual phone would change the data. So nothing about the basis being a same phone, same iOS, same settings, et cetera, just quote unquote her testing. And she used that same explanation in this particular case as the methodology that's generally accepted that supported her opinions. While Ms. Hyde explained her testing done for peer review purposes, she provided no correlation to explain or acknowledge differences or similarities in the devices. Okay, you just said that. Moreover, this seems to skip a little bit. Oh, wait, that's my bad. Let's go back to the first page. We're still on track. Moreover, she did not retain her notes, her data set, or the computer used to conduct her testing, which formed the basis of her opinions. She acknowledged that Apple is continually updating its operating system and settings. Under the circumstances, the court is left to rely on or accept the ipse dixit opinion of the expert. Interesting. Ipse dixit. You don't say. You don't say. So this is a Daubert hearing, and her methodology, her basis, her reliability, these things are all in question. And this goes to replication, the ability to replicate her results, to be able to see exactly what she did and how she did it, and review all of that. Wasn't available in that case. Have no idea if she made any of that available in this case. The issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. While Ms. Hyde is certainly knowledgeable on the subject of significant locations data, she acknowledged limitations due to Apple's proprietary algorithms, such as she is unable to determine the specific sources of the location data which make up significant locations. She does not know the number of data points Apple is using for significant locations. She does not know the level of priority in the data points used, and she has no idea how Apple generates a confidence score as to the coordinates provided. These unknowns flow from the proprietary algorithms. Didn't really get a connection, at least on direct, between her confidence or inconfidence or the limitations on her opinion or anything like that, specifically being tied to you don't know Apple's source code. The reliability of the methodology for the data provided is of paramount concern for both parties, as it should be. While the reliability inquiry for expert testimony is flexible, reliability cannot be presumed. That's a very important point. You can't presume it's reliable. They have a burden of proof to establish it. When determining the reliability of proffered expert testimony, the trial court must focus on principles and methodology, not on the conclusions they generate. This is from Abrukwa versus State in Maryland. Oh, I know this decision that's cited. This is the one where the Maryland Supreme Court found that the ballistics methodologies that purport to say this gun fired this bullet, this shell casing came out of this gun, they aren't substantiated. Maryland no longer allows that specific opinion to be presented in court because there is no scientific basis to say to the exclusion of every other firearm in the universe. However, conclusions and methodology are not entirely distinct from one another. Thus, the trial court must consider the relationship between the methodology applied and the conclusion reached. Under Daubert, trial judges are not required to make a determination of the ultimate scientific validity of any scientific propositions. Instead, they need only make a much more limited inquiry of whether sufficient indicia of legitimacy exist to support the conclusion that evidence derived from the principle may be profitably considered by a fact finder at trial. That is a little bit wordy and grand, but they don't have to actually say this is good science. They just have to say there's enough here for me to think it could be. A jury could find that it's good science. The trial judge is charged with the responsibility of a gatekeeper. See id. Under Daubert, trial judges are not required to make a determination of the scientific validity. Instead, they need only, with screening and oversight role, the gatekeeper must ensure the expert's testimony rests on a reliable foundation. In this case, there are a number of unknowns, too many for this gatekeeper. Before a fact finder, the unknowns could easily result in a default to acceptance, which is not appropriate or consistent with the quality required and expected in scientific/technical evidence. This is like a breath of fresh air, a court that cares about science. There are too many opportunities for the fact finder to simply rely on the expert's verbal confidence as opposed to reliable methodology. The very fact that a person gets up on the stand and says, I'm an expert and here's what I think, is putting their thumb on the scale. So they have to be able to back it up. And as we know, as we've talked about many times, this has been an issue in forensic science for decades. A lot of junk science presented doesn't have a valid methodology or basis. The state has the burden of persuasion by a preponderance of the evidence. The court, having considered the Daubert factors, the evidence presented, and arguments of counsel, finds the state has failed to meet its burden. Accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell phone extraction is granted. So, significant location data doesn't seem to be part of her analysis in this case, at least not, based on what we've seen so far. I'll go ahead and take us back to the trial stream. We're still on the light, but I'm seeing some captions come up. So they're chit-chatting, where the mic can pick it up, but we can't hear it. Sometimes, they just talk about sports, but sometimes they talk about other things. So anyway, we'll just let that sit up. See if they say anything interesting. So significant locations data is not the subject matter of her testimony, at least not that we've heard so far. It does seem like we've covered both of the opinions that she says she was retained to provide. So don't think there's anything else for her to do on direct here. We are anticipating going into cross. Is that a reason to keep it out? I'm not sure that it is when she's describing what her methodology is, and that includes things that were part of her methodology here. And the court says that's not enough. That's not reliable. That seems to be pretty relevant. That seems to be pretty relevant. If your research doesn't count because you haven't established that it's similar, you use similar devices, you haven't provided the basis for it so that we can establish that it's replicated. Oh, this is we getting notes of something else. Not quite sure. Not quite sure what they're chatting about. It is interesting to follow that sometimes. What comes up in the captions from the court, even though we can't hear it with our ears. Some kind of chit chat happening. So, should that come in? Is it relevant? Does it have the tendency to make the existence or non-existence of a fact more or less likely? In other words, the reliability of her methodology, does it make it more or less likely that her testing is not a reliable way to reach these conclusions? Yeah, it seems to me that it does. And based on that, the weight that the jury should give her testimony, yeah, seems to me to be pretty directly relevant to that. So you got to have substantial prejudice if we're going to justify excluding it. Substantial prejudice. And all we got was, well, this other rule that really doesn't apply to this situation, because I don't know that we're talking about canons of construction, how to interpret the language of rules that are ambiguous. Don't think that's what we're talking about. We're talking about, does he get to cross-examine a witness? So it would be, the limitation would be relevance, and it would be, is it substantially more prejudicial than probative? I don't see how there's substantial prejudice to letting him get into that. So I think that's a pretty problematic ruling. And given the centrality of the whole 227 search to the third-party culprit defense, the theory that somebody else committed this crime, that's evidence of guilty knowledge. If that happened, 227, you're not supposed to know. So it's a very, very significant piece of evidence. Because of that, the potential effect on the outcome of the trial is huge. Is huge. All you have to do is thought experiment. What if the jury was told she searched Google at 227 for Hoslong to die in cold? What kind of effect do you think that would have on the jury in terms of their verdict? It's significant. So I think this was a bad mistake. I think this was a bad mistake on Judge's part. I do not see the explanation and the reasoning that she has given substantiating what she's done. And what she's done is limited Karen's ability to cross-examine the witness on a fact that goes to the reliability of her methodology, and therefore her resulting opinion on a fact that is pretty central to whether Karen Reed killed John O'Keefe or whether Jen McCabe is lying about how all this went down. And she, in fact, knew John was dead before finding him at about 6:03 the following morning. This one seems pretty significant to me, guys. See if we can get a couple more questions and comments in before they come back. Joshua Frost, if they had photos, wouldn't it be pretty easy to tell if the chip was actually a chip from another piece in the bag? You would think so, right? If they had documented every piece as they brought it up, you would think they would have a photograph of that piece. And so they'd be able to bring up that photograph and say, oh, here's this one. If it's a chip from one of the pieces in the bag, then you'd think they would be able to match it up. Just do a puzzle, show how they fit together. If they fit together, then, issue problem solved. Yeah, maybe just chipped off of that one. And that's why there's 3 when there's only supposed to be 2. The rural juror, is that a word? Daubertized? Alessi. He did explain it's common when they use it, but I won't use it in case it's dehumanizing to daubertize someone. No, it just means her basis has been subjected to review for reliability and kind of fundamental scientific validity. Are we getting sound in the court yet? No, it's still off. I'm just checking to make sure they're not doing anything. Sandy B, Andrea, today is the deadline for ARCA, so maybe. Oh, that's right. May 7th was the day they're supposed to submit their report. Well, they'll have until the end of the day, and I wouldn't be surprised if they take that whole time. You're rushing stuff through. Yeah, today was the deadline. Thanks for that reminder. Josh H, Safari is part of Apple's source code. I don't think they have the source code for Safari either, though. I'm not sure that they do. That's not typically how these forensic tools are working. They aren't going in and analyzing Apple's source code to understand here's how Apple programs these things to work, to run their functions and to store the data and so forth. They are looking at the outcome and trying to reverse engineer it. They're trying to figure it out from the back end. How can I make, a phone with the same phone with the same operating system create this same artifact by using it? And that's how they ultimately figure the stuff out that they testify about. Because they don't have Apple source code, so they have to look at what the outcome is, see if they can recreate that outcome, and understand the general structure of how the phone works based on that. The rural juror isn't, have you been rejected by any court, a normal question? That seems in line with this type of stuff that Alessi wants to go into. Yeah, that is a pretty normal.
In the beginning, one of my functions is to make sure that a case is tried fairly and efficiently, and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I am, but if I seem to cut somebody short, the lawyers are just doing it when they request sidebar conferences.
She's trying to cure
all sidebar conferences to a minimum, but the lawyers are just doing it.
Oh, but then she defends it.
All right, go ahead.
She's trying to cure that comment.
I just need a witness.
She's trying to cure that comment that she made. They brought that up at sidebar. You need to give a curative instruction. Yeah, that's right. I mean, you shouldn't have said it in the first place, and you know that. But we're trying to keep sidebars to a minimum.
Certainly.
But the attorneys are just doing it. But then she doubled down.
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
Previous trial again.
It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Yep. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20, yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Ms. McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus. Do you recall that case?
I do.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that, quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent. I do not have that amicus in front of me. It has been a year and a half since I've read it, but that amicus does discuss frequent location history records, and I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case. Is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one, which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page
What about that lock the phone?
1529 in that report.
Page 15?
Page 1529.
The report is.
Would you like the
50
page
pages.
of the report or the page NDA number at the bottom? I can do either
Oh,
way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top, it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. Do you see that statement?
Yes.
And then if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct?
Mm-hmm.
You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I
Getting a
read
little
that
red,
correctly?
isn't she?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
Object.
Can you answer that? Who's Hyde? Can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39.
Okay.
And it will be, thank you. And if we could go to slide 82, please.
Indeed.
And Ms. Hyde, if I could draw your attention to the entry that is It says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on Direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
You said it was the last.
Is there anything that had prevented you
How
from
come you didn't see
reviewing
it?
that in that data before you wrote this report?
Yeah.
Not that I can think of. I would have to go and re-review that.
My question is,
I don't know if that artifact, I have not reviewed that artifact. so I
frustrated.
cannot
She doesn't
speak
like being
to an
wrong.
artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report. So I cannot speak to that without going back and reviewing that evidence.
Isn't the
You made a
interaction
claim, you
device
can't
lock
back up.
button readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
Oh, she is mad now. So she tried to hide behind I didn't
If
look
you
at
could
it.
please
Just should have
turn
looked at
to,
it before
in the
making
same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that. And if you could now just go to the conclusion, which is your page 50.
Did you find an internal inconsistency in her own report?
Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing, text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis? I
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, turn to page 1535 of the same report.
Can you give me my page number, please?
I will.
Okay, thank you.
You're welcome. If you could turn to your page 13.
13, Roger.
Here come the sirens.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the questions. I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were citing?
I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Sure.
isn't it correct that it isn't my theory when the steps ended?
Oh, it's not,
If I could just finish,
Please, absolutely,
because if we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory, it's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which just doing the simple math is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page
So red.
1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I just center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome.
The over
Just
the
let me know
top
when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mhm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
More than
That
3 minutes.
191.253 seconds equals 3.2 minutes,
Approximately, yes.
approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well.
Oh, great
Now what
point.
I'd like to do
So you're right then?
is
Yeah, I don't know
to
about that.
turn to the phone of Jennifer McCabe.
Okay.
And that is for your reports. You don't date your reports, so I can't give you a date, but it says.
It's report 3, I believe, is what. you're looking at.
Exactly. It's 3. And there is, bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page for that
Absolutely.
time?
And
I do
if it
see
is-
an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
Oh, interesting. He just turned her into
And
his
again,
own
this
witness now.
call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
Yes,
Mr.
okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right.
It shouldn't even be there from her previous explanation.
Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp and you would find that parlance acceptable.
Yes.
Thank you. So I'm going to do that, just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case. That
and
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could
She doesn't know where he's going
go
yet.
to
Eye
page
narrowing.
5 of that report.
Is there there's a trap.
And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, house long to die in cold, was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings.
Mm-hmm.
It starts with, there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device, right?
Yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Did you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
And we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m. January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 2:27, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right, so we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the time stamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next to it.
Correct.
Did you?
They should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have two additional times in addition to the two times, two different numbers added to the two, correct?
The UTC was a typo. It should say UTC next to those. And the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So
contend that? You'll admit it.
In terms
You'll
of
concede it. You're just contending everything because you're being argumentative.
2023 report, your first report in this matter.
Yes.
Let's get back to how our opinions have changed.
You on page 5,
typo was written
sentence underneath the block paragraph state,
instead of UTC.
In the instance of the Google search, house long to die in cold that was recovered from the right ahead log associated with.
That's correct.
The X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report?
Yes.
Okay, so now what I'd like to do is to go on to
Yikes.
the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
They're impeaching her after the fact.
I am now
Sure,
going to
they
go
report.
to that testimony, and if at any point you would like to have a copy of that, if Your Honor would like, I will do it, but I'm going to start and then we'll see how it goes. So, bear with me a moment. Do you recall in that testimony stating that,
quote,
you processed the image in several forensic tools? I use Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12. You're welcome. So,
this is such a
do you
beautiful impeachment.
recall giving testimony about the various tools you use for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I spoke to the
enough.
tools I
Jen
used.
McCabe-like. I don't remember my
Your Honor?
exact words.
Yes, Mr. Alessi, you offered a transcript. Do you have the whole
I have the
transcript?
whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one else provided. Ms. Hyde, I'm going to give you a transcript.
Thank you. I appreciate it.
Thank you. I appreciate it. She gets extra snarky with her bubbliness
So-
when she's not happy.
112. You are. Is that let me turn it over to
Thank you. I appreciate it. The battle of the politeness is one of the funniest things when you have people
Thank you so
trying to
much.
outdo each other with the
You
high
said we're
ground,
on 112?
Yes, please.
but someone's pissed. Thank you. I
113, I see
appreciate
it.
that. You're welcome.
I see it's highlighted on the copy, so I
Right,
figured
so
that's
what I
what.
wanted to do, the reason I said 112 is that's where I
Oh,
started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding. So it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did. That's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor. Thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony.
Just walking her down the primrose
And
path. He is
Feel free
not
to
a
go
plan.
back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold. Do you
Can I have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 12313, but if you need to go back further, feel free.
I mean, this is the guy on a mission. No hesitation in his step whatsoever.
Okay,
Knows
I'm good.
exactly
Thank
where
you.
he's
You're
going and
welcome.
what his weapons
So what I
are.
want to do is start with page 1-23, and this is your testimony. On line 16, I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that correctly?
Yes.
And that's associated with the Google search "house long to die in cold" in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now, if you turn the page of the testimony.
Because if he's the dumbass, yes, correct. Like we're in kindergarten.
You state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
You did.
Not one thing, you said it could be lots of things, correct?
That is correct.
And then you go on in line 10 and you talk more, and then you go down to the bottom. You go down to line 20 and you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that give in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
She's getting red again. She thought she was done and had handled that.
If you go to page 129 of this transcript.
I'm there.
At the top.
Sure.
Line 1. 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember, we were just reading your undetermined in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to page 130 of your testimony.
I need to object.
Right. I'll see you both.
Now Hank's going to object. Of course, we're trying to minimize sidebars, jury. So, my lack of frustration with Mr. Brennan, don't pay any attention to that. Yeah, that way she started off the session, correcting herself. That was, she got called out for that comment she made when Mr. Alessi asked for the sidebar. And she said, this is the last time, last one, Mr. Alessi. What you're doing here is not important. It's extremely improper. And she knew it when she got called out on it. So she went and gave that curative instruction. If I get frustrated, I shouldn't. It's my bad. Don't take anything from me. The attorneys are just doing their jobs. That's right. And they're going to be specifically instructed. The attorney's job to make objections and to make their record. And you're not to consider that or draw any inference from it. And so you, judge, are not supposed to imply that their doing so is pointless or a waste of time, like your comment did. That's what that instruction to the jury at the beginning of the post-lunch session here was all about. Boy, this witness, is she not coming across very likable, or is that to me? She's interrupting a ton. She's cutting him off. She's trying to get out ahead of his question. She wants to be the smartest one in the room and does not like it. Does not like it when somebody else might be smarter than her. She does not like being wrong. The smartest person in the room would never be wrong. How is there a phone call on Jen McCabe's phone at 5:07:21 if she just testified that all of the call history prior to 8:59 would have been deleted automatically by the device? How would that even be there? How would that even be there? It shouldn't be there. For her theory to work, this was a system activity, not a user activity, because of the 200 files. And so whenever there's a new one, it deletes the last one. 8:59 to the point of the extraction. That was the time frame that she said. That's all. There shouldn't be a 5:07 phone call in the phone. That's your testimony. It shouldn't even be there. The sing-song voice like she's talking to some kindergartner, it might work with some attorneys. It might work in some places. I find it very distasteful, but I also find it very ineffective with somebody as clearly sharp as Mr. Alessi. He's not a dum-dum. He's not a dum-dum. You shouldn't talk to him like he's a dum-dum, like his little concerns are something to just soothe and pat his head and give him a little snacky and lay him down for a nap. That doesn't come across very well at all, because he clearly knows what he's talking about. He's on point. He's got his ready. He's moving through all this systematically. He's making all of his points. Treating him like a dum-dum, I don't think is working here.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and get some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me, I think this may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly. So
am I correct that here, what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
on that date? That is correct,
okay,
yes.
so I just wanted to establish that. And you were giving Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's
and then Celebrite took it out.
Page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Celebrite and magnet axiom, and then you elaborate both Celebrite physical analyzer, which is a specific tool, right, of Celebrite, and magnet axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I used the specialized Sanderson forensic browser for SQLite, correct? I read
That is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur that you use the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. All righty, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have
it correct.
Chronology correct, Ms. Hyde?
That is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp. And in that report, under relevant findings,
or just do it again now that Celebrate doesn't include it.
And this is December of 2024, so it's from your May 2023 report. It's approximately a year and a half. Is that approximately from your May 23rd report?
Approximately.
Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, magnet forensic axiom showed up, that was removed by Celebrate, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom.
Your former company.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics.
That is correct.
Still shows that timestamp.
Yes,
right?
yes.
But Celebrite doesn't in the automated
That is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
Correct.
And you used many tools back then to analyze that timestamp.
Let me guess,
And you testified
1224
to those
should only
many
use
tools on
Celebrite.
your direct examination, correct?
Correct, yes.
However, in December of 2024, when you returned to analyze the 22740 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mm-hmm.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
That's a fair statement. That's a fair statement. Let me rephrase it this
Thank
way.
you.
You're welcome. In this report, you speak about Celebrite release reports, correct?
Are you referring to the Celebrate release notes that come out?
The release notes at the bottom,
Perfect.
right? You referred
Yep.
to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite's.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down all the way down to the conclusion. In that report, is there reference to any company other than Celebrite in this entire report?
In this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry. Can you please repeat?
Absolutely. No worries, sir.
Apple
Are you
source code.
familiar with the phrase Apple source codes?
Apple's source code? Absolutely. Yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it.
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct?
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I refer to that as the MB postulate, to shorthand it, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place to go is to the Apple source codes themselves? Or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, very, those are incongruent statements. Apple's source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation. We don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily, because that doesn't perform. Operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever have you ever spoken with Mr. Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That just is.
I have not had that conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
We have to.
Don't interrupt.
Oh, yes, I'm sorry.
It's all right, no worries.
Just did it again.
So you regard have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely,
And
yes.
you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the History DB of either of those two searches.
So I want to just
Interesting.
repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
Interesting.
You spoke about PYF, PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, a tool one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
Expect him to understand that or know it.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained the PDF that contained the hash values. Are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear. I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree?
His statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but
do you agree with the statement or not?
Nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone?
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking
the whole thing
on scene, taking the device into evidence?
From the very beginning.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data.
Just make her your expert.
Have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
please.
And I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. but do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device. So if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, Nick? Yes. Thank you, Your Honor.
God, she just starts, she takes it and starts running.
Bear with me. It's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find it. All right. So,
you don't have to say every word that pops into your head.
To a page?
Sure. That'd be great.
Thank you. If you could turn to that report on your page 47, and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So,
notifications from Ring, you don't say.
The iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or a Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not trying to
right
justify.
Wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct?
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday. I 100% agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on this phone.
Absolutely.
Which shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box. And that failure is not best practice.
Correct. It is not in accordance with the best practices. I agree. I would have Faradayed it.
Thank you. So
if I,
that's okay. I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Brennan Re Direct.
The battle of the politeness. Look at that look from Brennan. What's he doing here? He respects what Alessi just did. That's what that look said to me.
Of course.
Whenever you're ready.
Thank you, Mr. Chairman.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes.
Well, that's very important. We've already
It's
heard
easy
it
to
twice.
remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023, what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And will you inform why? Was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the district attorney's office?
My analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Oh, but this
Was
time
there
you
any
have had a lot.
input from any outside source on what your result or ultimate opinions would be?
No,
Would you ever allow anybody to affect your input?
no.
But you had a whole bunch of calls with Tully since then, didn't you? Somewhere between 10 and
Throughout
20?
the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope?
Yeah.
I believe we're talking about report 2. That's the one about the Celebrite change.
Yes.
And
Exactly.
I have the request was to understand changes made in the newer version of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrite actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrite's own statement?
Please.
Celebrite's statement in
To yourself.
to myself? Okay, roger that. Thank you. I appreciate that.
No, you don't. Just do what you're told.
Can you repeat the
Share with
question?
us,
Ellen?
was there any reason other than the concern about misinterpreting or
They said that
So
my understanding is that it is not a reliable timestamp, and that is why Celebrate removed it.
you were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrate Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrate before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended state DB artifact as carved.
Do companies like Axiom and Celebrate give releases, updates, information about how to interpret their reports?
Suspended state
So
DB.
Axiom
versus
actually
browser
has
DB?
a document that's released with it called the Artifact Reference Guide, and that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release notes. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from say 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you
Weird, because we don't either.
analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag, so usually those phones would not be Faradayed, but they
Use a
would
dead guy's
typically
finger to open the
have
phone?
airplane mode enabled.
How helpful
Or
of
SIM
you.
card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context to you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari plist, which tracks the history, as well as the Knowledge CDB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart.
Deleted
for
from history,
the difference
perhaps?
between the Knowledge C and the Mobile Safari plist.
Deleted history, perhaps? Didn't you mention that
On
in
direct
direct?
examination, you were not asked questions about Mr. O'Keefe's phone.
That is
but
correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022,
That is correct.
page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps, it could be you're carrying it, it could be that you're in some other kind of motion. You could be on a bicycle, you could, any number of things. The number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
Your Honor.
Well beyond the scope.
Yeah, I'm going to deny that question.
Can these health steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical, you could be in a vehicle, you could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you in cross-examination, do you have information or opinion where Mr. O'Keefe's phone was located around 12:21:10 while those steps registered?
Objection, Your Honor. So,
I think that's beyond the scope of the class.
Mm-hmm.
It was pointed out to you at 12:21:10 there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that began at 12:31:56 for 20 seconds.
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
Was beyond the scope, and Alessi even stated the basis. Objection scope, and she agreed it's beyond the scope.
That appears to be the last before the 6 a.m. hour.
So that 20 seconds, if it began at 12:31:56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at 12:31:56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyzed the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04?
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't, that wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up?
Yes, please, Your Honor.
We have a moment here.
Is there a difference between suspended state.db and browser state.db? Are they the same thing using different terms, or are these different things?
Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the.
Thank you, I appreciate it.
Yeah. And I'll repeat the question.
Thank you.
Mr. Alessi can wait patiently until it's his turn to speak. Watch and learn.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other.
I'm sorry, my question is, do they state in the release note whether there's a reason for why they concluded?
May I look at the release note again? Thank you, ma'am. Thank you, Your Honor.
And please try not to talk.
Sorry, Your Honor. 2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion, not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank you.
You're welcome.
You're welcome. The battle of who can be more polite while we're eviscerating.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but.
All right, but they don't state what the further research is.
That is correct. They
All right,
state
now
that
what I'd like
it's
to do
unreliable.
is move on to Axiom. You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes, Celebrite, currently, previously, when we did the first case.
Right, but currently, Celebrite doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp?
That is the timestamp that they show for that artifact.
Exactly. Correct. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. you talked about one example of maybe needing to use a biometric to unlock a phone. And that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to...
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
Fair enough, but from 6:04 a.m. until approximately noon
Correct.
on January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
But you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6 a.m. to noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022 until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But yeah, it does not appear to have been placed in Faraday bag.
All right.
No, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to...
No, just the Stop and Shop bag is the same thing.
Hopefully, what are the last two categories of questions? With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? You know that.
I'm uncomfortable with the term auto-deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs. And what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions.
What?
Where
Biome?
you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So If data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't it correct that that phone was moving at that time?
May I check the timestamp again?
Absolutely.
I apologize. There's
no.
a lot of timestamps going back and forth.
Please do.
12/31/56, is that
Yeah,
the?
that's the start, yep.
Oh, yes, this one there definitely is. Yes.
So,
Definitely is.
doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes.
Thank you. I appreciate again you answering my questions.
Thank you.
You're welcome.
All right, Ms. Hyde, all set.
Thank you, Your Honor.
All set.
Alessi Council about scheduling.
Yes, there's
Okay,
only a
so
half
this-
hour left in the day. So let's go ahead and chit chat about scheduling. They're going to finish early, probably. I doubt there's going to be a witness that they expect to get through in half an hour. Well, boy, there's going to be a lot to go over here, isn't this, to recap it? That was just a masterful cross. Boy, very impressive. Very impressive. What'd you guys think? Did it seem like he was making his point? Oh, Mr. Brennan wants to ask some more?
May I?
Yes.
I would like to play clip 15, please.
Oh no, clip 15.
Hold it was Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Oh, you really want the jury
So,
to think that?
folks, I talked to the lawyers briefly about scheduling at Sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful activity. So
Yep.
we're on schedule, ahead of schedule. We'll reevaluate that tomorrow. I know you will see the lawyers at Sidebar asking for as well about to talk a little bit about scheduling. Okay, same cautions, please. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with the session you use. We'll see you tomorrow morning. Thank you.
All right, the court, please. Close and open, follow me.
Boy, what do you think? Do you think setting
corner?
that up as it's Karen or Jennifer McCabe is the distinction the Commonwealth really wants to make? You think it's me or her is the distinction you want to make? You think the jury is going to side with her so far based on all this? You think the jury is going to side with her? I don't know. I don't know if that either or distinction is quite what it's in the Commonwealth's interest to set up here. Maybe they have a different perspective on how Jen McCabe came across in all this. They're doing something, but I can't tell if they're just moving around. They're having their sidebar. Court's been kind of just going past the fan and so forth. I'm going to leave it on. I guess I'm going to leave the sound on just in case they come back and something starts to happen. If that messes up my sound, sorry, it will be temporary. Well, so we started the break with her saying, no, you don't get to cross-examine Jessica Hyde on that case from Maryland. We talked about the reason, the problems with the reasoning there, the fact that it's not responsive. You know, she had to go research her independent basis, her independent rule to say, no, I'm not going to bring it in. She relies on a rule of statutory interpretation. There doesn't seem to be an issue with vagueness in the language of a rule or a statute. So really not clear why that, is what she turns to. You don't use rules of interpretation to say, I'm not going to apply this other rule, because I don't want to. Like that's not how it works. If you have a specific rule that says how a particular piece of evidence gets handled, that's going to control, not do I think it's efficient and simple and fair in light of the policies of the rules. You don't second guess the rule. So potentially big issue with that ruling, but he did it anyway. We'll get to it. So her testimony on the search, the 227 search, is essentially the same as Ian Whiffin's. We talked about that. It's pretty much duplicative. She's saying that this timestamp comes from the time when the browser tab, something was done with the browser tab, and the timestamp is referring the activity with the browser tab. And it's just been updated. That time has been updated with the search that she actually did at a later point. So that's her explanation for it. However, her actual conclusion, she uses some just very interesting language. The tab was opened at 227, and that search was done there. Okay, so tab was opened at 227, and Hoslong to die in cold search was done there. She says that. Looked at all of her different tools and so forth, and people misinterpret these timestamps a lot and so forth. She looked at all these different instruments and dug deep and did her own testing and so forth, all of which is extremely ambiguous, very vague. What testing, on what, how, etc. Multiple databases show Safari search info, including the plist, the browser state.db, history, knowledge CDB. So these are the four that she stated she primarily relied on. But then when she's talking about Axiom, she's saying suspended state.db. I got confused about this. You got to be consistent with your terms. I think these are talking about the same thing. They're just different names, but that would kind of surprise me because I would think it's coming from, the file name. And so that would seem to suggest a suspended state.db is something different than a browser state.db. Very unclear. Very unclear. Some of you tech folks in the chat may know if those are the same thing or different things. But that is what she says, Axiom is pulling from. I don't know why they would have different names, but can't really say one way or the other. It's just confusing. So she created her, recreated her timeline of how she thought the order of events was, and 227 was the tab created, but it's actually the last event because it's when the search Hoslong to die in cold was done later. It updated that 227 tab. We had a whole issue with objections to her methodology. She was specifically asked if there was an accepted methodology to analyze the data, and all she said was like, well, I did all of these things, and I've taken classes and I've helped review policies and things like that. She gave her resume. She didn't actually say yes or no. There's a methodology and where the methodology is from and what it is. But that didn't seem to matter. Judge Cannone seemed to be satisfied with this rather vague reference to her methodology. So she gave two opinions about the 227 search. She said that the Hoslong to die in cold search occurred at 6:24 a.m. It was the last search in the tab that was opened at 2:27. But when she was asked, were there other searches on the tab before 6:24, she said she can't say with certainty what happened in the tab before. So she can't rule out Hoslong to die in cold was also searched in the tab before. She can't rule that out by her own testimony. She then looked at whether it was user deleted, and she just came to the opinion, no, it wasn't user deleted because there's no way to delete a tab. A user doesn't have a way to delete a tab. It doesn't exist in the phone's architecture. So my question would be, are there other ways that this artifact could be deleted other than just interfacing with the phone settings or the phone apps or whatever? Is there another way that a person could get into this phone and delete that particular artifact, including, for example, could I write an app to do it? Could I write an app that would cause this data to be reported in a specific way? Now, recognizing I'd have to know Apple source code to be able to do that. But so hypothetically, could an Apple developer write an app to make it do that? Seems to me like it could. I don't know. Folks in the chat, let me know. Let me know. I know we've had some developers out there, some programmers. Boy, that whole long explanation, then we started to get lost where she was going into the pizza and the waffles and the wall file and what this has to do with everything else. Guys, I'd love to be able to articulate that and spell it all out for you if I could, but I don't know that I can because I don't know what she's talking about.
I'll see you tomorrow morning.
All right, they're done tomorrow morning. Keep an eye on them, but I think they are done for the day. So there's no option to delete the tab. You can clear your cache or clear the history, right? You can clear the history of your searches. You can go into your history and you can delete a search from your history. Yes, you can. But you can't go in and delete the tab. Therefore, she concluded that the tab was not user deleted because there just isn't any way to do that. Then as far as the phone records, she says there's no user deletion, that it only records so many. And so you can, the recent call logs would delete anything exceeding 200 calls, which is the last 200 calls is the storage capacity for the phone. So as soon as you have 200 phone calls in your storage already, you receive a new phone, it's going to go in and delete the oldest one. It's almost always a first in, first out. I remember that from the last trial. She didn't say that specifically here, but that was, I think, the gist of what she was saying, the 201st one. So the oldest one would be deleted. And so as of 8:59 a.m., there were exactly 200 calls in the record. And so anything before that would have been system deleted. That seems to be what she's saying. Anything before that would have been system deleted, not something that the user did on purpose. It's done by the device itself. So then we went to Cross, and everything she has on there with the stand with her. Kind of do enjoy that. So let's just spell it out. What are all the things you're looking at there? He started to ask about the Herrera case anyway. Judge says you have to move on. Then she submitted an amicus brief, amicus curiae. She took a very strong affront to the idea that this was on behalf of the prosecutor. It certainly was not. It was a position on the evidence. It was impartial. I thought that the evidence was reliable and should be used. Alessi didn't really drive this point home. If my understanding of where he was going with it is, it sounds like her position would have ultimately benefited the prosecution in the case. If the court adopted her reasoning, would it have benefited the prosecution or the defense? I think that's probably the way to spell that out. That's why he's saying you're arguing for the prosecutor, right? You're defending their position. And she's saying, no, I'm impartial. But the point is simply, okay, but if the court adopts your position, the state wins, right? You're advocating for a position that benefits the state. That really didn't get clarified, but I don't know that that's the most important thing in the world. Bias with stuff like that, sometimes it matters. I think most of the time it doesn't. People just kind of expect that experts are hired guns. Of course, they testify for whoever pays them. And if you typically testify for prosecutors, then yeah, your positions are probably going to typically benefit prosecutors. So he started with that error in her report, and that just rattled her. That rattled her right from the very beginning. She turned into that over polite, that snarky, interrupting, trying to get ahead of him. And that was because in her first report, she stated that there was no indication of user action with the device after 12:20, whatever a.m. on the 29th. But there were those steps. There were the steps at 12, and there was the lock button. And she says, so they confronted her with Ian Whiffin's report where the lock button was pressed by a user at 12:32:09. And Mr. Whiffin had said in his testimony, yes, that requires user interaction. Somebody has to physically push that button for that to happen. And she said, well, I didn't review that artifact. Well, but you made a conclusion about the condition of the device, the activity of the device between certain time frames. So you're not looking at that artifact seems like a you problem. Like that's the point, isn't it? You missed that artifact. You missed that artifact in your very careful review and analysis. And yes, seconds can matter. She conceded that. And nothing prevented her from looking at that particular artifact and including it. Had to concede all those things. So the conclusion from that is pretty clear. It was readily available, but she missed it. She missed it. Oh, and then she was hot under the collar after that. Because this witness likes to be the smartest person in the room, and the smartest person in the room is never wrong. Never wrong. But we started off with her being wrong. She was wrong, and she did not like that one bit. Then we went through some other inconsistencies. The 12:31, she says, was the last user interaction, but it actually stopped at 12:32. She tries to cut him off. I know where you're going. Well, and then he's walking her through systematically, and she starts using her sing-song voice. That is correct. That is correct. Like she's talking to a kindergartner, and we're telling a fairy tale together or something. And then she just quibbles over, well, movement isn't direct interaction with the screen. If we wanted the time when the movement ended, yes, it would need an additional 20 seconds. The point is the user action didn't end until The steps were done, right? No, she said, that's not what I meant. It's not what I meant by active interaction because it's just walking. If you didn't mean it was active interaction because it's just walking, then why would you call it active interaction when the steps start, but not when the steps end? Walking is an active interaction as an activity in general, or it is not. So you don't get to be like, it's an active interaction when you start walking, but not when you stop. No, the whole thing is or isn't. So that was her explanation. Well, the user interaction isn't really walking. Well, but you called it that, and you logged it as that. So the point here is that you could get a misleading impression from her report. If seconds matter, and the fact of the steps and when the steps ended is a critical issue, her report appears to be wrong on that. That was the point of that line of questioning. They're being just over the top polite to each other at this point. This is I love this is why I love Alessi's style. Look, he's armed with the facts. The facts are your fists. Facts are your fists. He's got them all. He's got them all backed up. He knows, is it in your prior report? Is it in your prior testimony? Is it in another guy's testimony? Is it in the release notes? He knows exactly where all of his information is that he is hitting her with. Those are his fists. And so he doesn't have to be snarky. He doesn't have to argue with her about it. He gets to actually be calmer and more polite and solicitous than she is. I appreciate that. Thank you. No, thank you. No, you're very welcome. And then you get both of these people smiling at each other, trying to keep the high ground where they hate each other's guts. He's sitting there going, you liar, you sloppy analyst. She's sitting at the thing, you tricky defense attorney. You misunderstood. You're misinterpreting me. You're skewing what I said. I'm right. I swear I'm right. Interrupts him. Not really consistent with trying to win the politeness battle. Interrupting somebody, cutting them off, speaking over them. They haven't even finished their question yet, and you're already going in to explain yourself. May come off as a little defensive. She's not listening to listen. She's listening to answer. And so she's already, she thinks she's the smartest person in the room. So she thinks she already knows where you're going. And I'm just going to cut you off and start answering before you get there. And then the 12:21, 10 a.m. is when she said the last movement that the phone registered, but the movement didn't end until over 3 minutes later. Over 3 minutes later, 12:24. Interesting. Note that timestamp. 12:21. Then it ended 3 minutes later. So 12:24, steps are done. Those 91s. She again just reported the beginning time. And if you're trying to say the phone's last activity, until 6 was then, well, it definitely was not. I mean, we know that just from the pocket state clearing, the pocket state not clearing, the steps that are being taken, and so forth. But even that one, just taken independently from the source of the data that she's using for the stamp, this marker in time of when the phone stopped moving, it's the beginning time of the steps. It's not when the phone stopped moving. It's when the phone started moving for the last time and finished moving 3.2 approximately minutes later. There's the phone call from Jen McCabe's phone to Coco at 5:07:21. She sees an outgoing call. Why is it there? Didn't she just tell us the call log history is deleted automatically prior to 8:59 on that day because of the 200 call limit? Why is this call even there? It shouldn't be there. unless they're in different databases or something. These are different sources of information, but you didn't spell that out. That's really unclear. I don't know why that call would be there. She'd never discussed that call with the Commonwealth. Intriguing. There's no duration listed. There's no population of the call duration from 12:14:13 until 8:59:34. She said yes, and it's explainable. And he said Brennan can handle that on redirect. Brennan did not handle that on redirect. Spoiler alert, he didn't go back to it. Then he turned to your opinions on the time stamp have changed from May 2023, the first report that she did, to today. She's no, that's incorrect. How many communications with Tully? Tully submitted the request. She doesn't really know how many, more than 10. Not sure if it's as many as 20. Somewhere between 10 and 20 phone calls she had, or communications she had with Detective Tully. Now, is it possible these phone calls or text messages or whatever they are, emails, are just, hey, how's your report going? Gonna be done soon? Sure, that's possible. Although she did get her report done pretty fast, so not really sure there would be a lot of extensive follow-up like that. So what does it sound like? Sounds like they're chit-chatting about the case, about her progress, what he's trying to find, how can we refine it, things like that. That means the process is not blind, and it means the process is not unbiased. Or at least we can't ensure that the outcomes that she reached were not driven by information and or desired outcomes that Detective Tully was communicating, whether overtly or inadvertently. Just telling them about the case. We're charging Karen Reed with murder. They discovered his body at 6:04. There's this Google search from another woman's phone at 2:27. We're not sure if that's accurate, and it would seem to suggest that she had guilty knowledge that she shouldn't have. So we want to know if that timestamp is invalid. I mean, I didn't tell you specifically which outcome I wanted you to reach, but did you get the idea from how I said that? That's kind of how things work. So she got the Haas Long to Die in Cold search from the WAL file associated with browserstate.db, and it was marked as deleted by Celebrite. And she said she looked at the Safari history that was associated with the search terms. There's other timestamps she looked at, 6:23, 6:24, but those are the relevant one. And her finding was a Google search for Haas Long to Die at Cold was at 11:23 and 11:24. Then she clarified that's UTC. That's not local time. Well, she didn't put UTC in the report. That's a typo. She says that's a typo. It probably is a typo. It probably is a typo, but it's pretty significant. That's a large number of hours difference. So she conceded it should say UTC. It's a typo. It's really not a typo. Typo would be if you accidentally wrote like UTB or YTC or something like that. You know, you hit the wrong key on the keyboard. It was an omission. You might say it's a scrivener's error. Should be in there. It wasn't. She left it out. May 23rd, she said the Haas Long search was recovered from the WAL log associated with browserstate.db. We're getting closer now on Cross finally to understanding what are you looking at? What are the relationships between all these terms that you were throwing out while you were trying to tell me about pizza and chicken? And she said, testing shows great inconsistency with timestamps parsed from the file. but page existed in the tab, and the exact reason the 227 stamp is listed is unknown. As of May 2023, she didn't know why the 227 timestamp would show up on that particular, associated with that particular web search. Then in the first testimony, she agreed it's important to use multiple tools to compare and contrast. She focused on the Sanderson tool to look at the SQLite database. I kept thinking that we might get into that, but I don't think we did. Just kind of emphasize that. So again, it could be lots of things that cause that timestamp. According to her testimony, you can't tell by the particular artifact when the search occurred. You can't tell by the particular artifact. And 227 isn't necessarily what time the tab was closed. She said it was undetermined. And that's because a lot of things can cause that stamp to be there. She doesn't know exactly what caused that tab to get that particular entry. That's her previous testimony. Hank had tried to slip that in. He tried to, this is a little bit doing her dirty because she didn't actually say, here's my opinion as to what the tab means and so forth. But Hank kind of slipped it in there that suggested she had an opinion that this search did not happen at 227, like definitively no 227 search for hustling to die in cold. She specifically did not opine that. She said, I don't know what happened on that tab before 624. All she knows is the search was done at 624, but she doesn't know what happened to the tab before that. So Hank did her a little bit dirty with that. And Alessi has come back here and set all that straight. You don't know. You don't know what causes that timestamp. You have no idea what was happening in that tab. Then she did this December report after Celebrite did their update. At this point, they removed the timestamp. And in this report, she didn't mention any other tool that she used. Now, she said she uses at least 4, but her report didn't seem to say that. And the Celebrite release notes indicate they removed the timestamp value, but Axiom still reports it. It reports it as this carved data. She disagreed. They argued about whether the best source of information about how iPhones work would be the Apple source code. She's going to actually argue with that. Of course, it's the best source. Nobody says a human being has to sit here and parse the data and know the code and be familiar with it. We live in the age of AI. You're telling me an AI that knows the Apple source code isn't going to be able to do, assuming it's an honest AI, right? Maybe a big assumption. We're going to assume it can't do a better job of telling us what that iPhone is doing and how it's doing it, why it's producing this data, because it can read the zillions of lines of code. Then you going back and doing your testing, nobody's going to buy that. Whiffen didn't buy that. Whiffen disagreed. And he pointed that out. He's now turned Mr. Whiffen into his own witness before we get to him turning her into his own witness too. God, it's just so good. It's just so good. No, the best source of data isn't the source code. What a ridiculous position. I'm not out of line with that, am I? Of course, that's a ridiculous position. If you knew the Apple source code and the reading the zillions of line is no object because you're an AI that can read zillions of lines of code in fractions of a second, yeah, I would think that would be the best. I would think that would be the best source. Got into some back and forth about the PDF being unsigned versus the hash being unsigned. So we established that the PDF was not signed, and that the PDF is created using this PyPDF Python code script. I don't know if that's going somewhere. It seems to be been from Gray Key. Is there like an implication that we could fake that? I don't know. But just little points that have been raised. She doesn't know anything about the history of the extraction of Jen's phone. Turned her into his witness. Why don't you tell us what would be the best practice from the time that phone comes into the possession of law enforcement until you're extracting it? What's the best way to do that? So you would isolate it from the network. Very first thing you would do, isolate it from the network. You would put it in a Faraday bag, or you would put it in airplane mode. Otherwise, invalidate, or disable the communications. You would keep it in the same battery status. If it's on, it's on. If it's off, it's off. And then after that, the type of extraction you would do just depends on the phone and the model and the support that your extraction tool has for that particular model and iOS and everything. And then also depending on whether you have a passcode or no passcode. Turned her into his expert by spelling out, this is the best practice. So now we're going to be able to identify how we know those best practices weren't followed in this case. What we know about the phone so far, the story we've been given about the phone so far, is that Carrie Roberts picked it up after the paramedics, the firefighter paramedics, put John on the backboard and moved him into the ambulance. She saw it on the ground, so she picked it up. She pointed it out on the dash cam video on the screen when that moment took place. It's about 6:15. Problem is, of course, phone starts moving before that. Phone starts moving a good 10 minutes before that. But she says she picked it up and then she gave it to a first responder, an unidentified first responder. She doesn't know who it is, no recollection. And we don't have, so far in the case, any first responder coming forward to say, I'm the one Carrie Roberts gave the phone to. We don't have that. We do, though, have this group chat in which Jen McCabe makes this perhaps ambiguous comment that we handed off the phone to Carrie. She explains it as, Jen explains it as, oh, I was just talking about my own phone so that she could talk to Proctor. Proctor had called me, handed off the phone. But you're texting on your phone. The interview is taking place at your house. This comment about you handed off the phone to Carrie as if it was your phone, it doesn't make sense in light of the context of this conversation. So do I think Jen McCabe is talking about John O'Keefe's phone? We handed it off to Carrie? Oh, 100 billion% I do. You better believe I do. That is absolutely what I believe she was talking about in that text. But we don't know. It's just a piece of information that's out there. We have no first responder saying, I'm the one that Carrie Roberts gave the phone to, so we don't know when. We don't know what they did with it. And all we know is at some point it ends up in the lab where it's being extracted by Trooper Guarino. That's all we know about it. But it's continuing to accumulate data. It's continuing to register new data. Totally not a big deal in this case because we actually got more. We actually got more data all the way up until at least noon. The phone was receiving data. No, we're not justifying it. The best practice, obviously, is putting it in a Faraday bag. But, the phone wasn't wiped and we actually got more data here. So she herself would have Faradayed it. She herself would have. That's the bottom line. It's not best practice not to. Put it in a Faraday bag so it's isolated from the network. The redirect that Mr. Brennan went into, oh, were you asked to reach a specific result? No, of course nobody asked that explicitly. They don't have to. That's not how the game is played. You know what they're trying to prove. And she even kind of gave them that. He asked her, well, were you given any context as to why they wanted you to look at these search terms? And she said, well, yeah, probably. You're supposed to say no to that. I had no idea. I was completely in a box, totally independent. No idea what the intended, what the theory was, what the use of this information would be, etc. No, probably she knew. Probably she knew why they wanted this information, but she wasn't asked to reach a specific result, so it's fine. And her analysis was very independent. In the first case, she had very little input from the Norfolk County District Attorney's Office at all, very little communication with them. Oh, but you had somewhere between 10 and 20 phone calls with Tully. So those all happened since then. They've been scrambling with this particular piece of information. Is that the conclusion I'm to reach? Celebrite, of course, updated. The reason why is because it was unreliable. That's what they said in their release note. Axiom's reference guide speaks to the possibility of misinterpreting the timestamp and the fact that it could be earlier than when the search occurred, but you don't know why these timestamps are created. So you have no idea if it reflects the time of the search or not. You don't know that. Situationally dependent whether you'd put it in a Faraday bag right away, because you might need to use the biometrics to open the phone. If you've got a deceased person, you might need to use their finger to open up the phone. You don't say. What an intriguing suggestion to be brought up on redirect. You might use a dead person's finger to unlock the phone. I don't know that that's a door you want to open. I don't know that that's a door you want to open, but there it is. Okay, so some of this activity on John's phone could be somebody using his finger to open it. Now we know that. The Haas long to die in cold search is not in the history.db. It's not in the history database. It's only in the P list and the knowledge C. So it doesn't mean the search didn't occur then. We have these other artifacts. No, it means it's not in history. And I know I, as a user, wouldn't know how to get into my phone and be like, let me delete this from the P list. Let me delete this from knowledge C. But would I know how to delete my search history? Yes, I would. That is something that you can accomplish with a user interaction. Is it not? Isn't it? I can go delete my history. These searches aren't in the history database like the place I would expect them to be if I hadn't deleted it. Steps, of course, once again, they don't necessarily mean steps. It just means motion. It could be a bicycle. It could be an elliptical. It could be in a car. It could be anything. It could be anything. It could be anything. I hope defense attorneys are like getting these transcripts, because I'm very confident that in her work for other prosecutors, she will talk about, health data proving that people took certain actions, went certain places, etc., based on steps and so forth. I would be willing to bet that she offers testimony like that. But now the health data is completely, it can mean anything at all. You can't put any stock on it. Definitely not saying 80 steps were taken. That's just what's stored in the database. Brennan tries to get into other areas. And did you analyze the movement of a car? Did you evaluate where the phone was when the steps were registered? Alessi objected to both of these. Sustained. It's beyond the scope. He even said it the second time. We're not supposed to, right? We're not allowed to state the basis for the objections, but he did it anyway. And it's clear, and that's how you normally do it in court. Objection, scope. We all know we're not arguing in front of the jury. We're not making a point that they're, concluding something from, and then the judge gets to say sustained. It is beyond the scope. Would that be so hard to do the whole trial like that? Objection, scope, objection, hearsay, objection, authentication, objection, foundation. Would that be so hard? Really, I don't think it would. Objection, best evidence, always one of my favorites. Yes, guys, I have won a best evidence objection. I have. It's one of the ones that trial lawyers are like, you're never going to win that one. I won one. I won one. I'll tell the story sometime. I've told it before, but not really that important right now. And this is redirect, guys. This is stuff coming out on redirect. The search isn't in history, and you can use the biometrics to open the phone. Might not stick it in a Faraday bag for that reason. This is coming out on redirect. But she doesn't know anything about the phone. She knows at 6:14 the phone is being moved, but she doesn't know what's causing that movement. He's trying to tie that back to Carrie, but the problem is the phone starts moving actually before that, doesn't it? Yeah, we know that it does. That's already in evidence. So then we get the recrossed, and we got to re-emphasize Axiom still reports this timestamp. Celebrate doesn't. Doesn't know if the passcode was provided, but assuming it was, is there any other reason why you wouldn't isolate the phone? Nope. The best practice would be to put it in a Faraday bag. Maybe the bag was broken. The bag could be broken. You got to test your Faraday bags. Okay. They going to present proof that somebody stuck this phone in a broken Faraday bag? Highly doubt that. Highly doubt that. Oh, this is very important. This is very important. This is one of the reasons why these efforts to secure the phone before you do the extraction are so important, because data can be overwritten. Subsequent activity on the phone can overwrite data that you need. We had a very significant example of this in the Richard Allen case, where once you turn the phone on and off, it deletes the current power log. And so you lose track. You aren't able to go in and find when was the last time this phone was powered on or off. Would have been an extremely helpful thing to know in that particular case, because we're trying to reconstruct the timeline. We have some peculiar phone activity, don't necessarily know how to explain it. Knowing if the phone had been powered on or off during that time frame would have been very helpful to use, but we did not and will never know, because the first analyst to get his hands on this phone turned it on. It was off. It was off. He turned it on. Deleted that, overwrote that log. So now you don't have that data anymore. So yeah, that's a really important reason to keep it in the bag, because things can be overwritten. Then we got that clip. She's done. Jessica Hyde's done. We got that clip. Karen saying, Jen McCabe, it's me or her. Is that the dare? Is that the dare you want to make? You really, really are betting big on selling Jen McCabe to this jury. And to me, I'm not happy with your chances of hitting that flush. I think you got a weak draw hand at best at this point. I'm not banking on hitting the flush. That Jen McCabe, at the end of the day, is going to come out of this looking so credible. Not sure we're going to get there. Weird decision by the Commonwealth, in my opinion, but they made it. It's out. That suggestion is there. So that was our day after lunch there, guys. That's what I got from Jessica Hyde. It is a little bit technical. It's pretty similar from last year. We kind of struggled through understanding all this stuff last year. That's the general gist of it. They argue that this stuff means, the timestamp means it's when the tab was created or moved forward or just whatever. But she's clarified they don't actually know that. They don't know. These timestamps can happen for all kinds of reasons. And she doesn't know anything about the history of that tab before 624. All she knows is that tab was used to search Hoslung to die in cold at 624. So with that, guys, let's get to your comments and questions. We got a lot in the queue to go through and quite a few from before the break. So AP, shall and shall not are my favorite ways to tell someone they have no choice in a legal sense. That pesky shall not be infringed sentence and whatnot. Yeah, that's some very, very strict language there in the Second Amendment. There's another one that I'm quite fond of myself. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Yeah, there's a few instances of that. Very common statutory interpretation principle, understanding. Shall means mandatory. You don't have any choice. Don't be hatin'. What about the Birchmore decisions? Shouldn't defense similarly be allowed to reference the missing text by Guarino? Wouldn't that go to his reliability even more directly? 100%. I don't think that this Birchmore investigation and its failings should be off limits to the defense. It goes to the reliability of the work that these guys do, and most specifically, it goes to their bias. It goes to their bias when they are dealing with a law enforcement suspect. The possibility that a cop did something wrong, then suddenly texts go missing, suddenly, hyoid fractures don't exist or don't matter. Suddenly videotape of the cop being the last guy to enter and exit the apartment around the time frame of the death. That doesn't mean anything. Just a suicide, guys, nothing to see here. It goes to bias. And because of that, there should be significantly more leeway for them to get into it. Cross-examination for bias is one of the most protected areas in evidence because it has this constitutional magnitude. And so, like I've mentioned before, I put a little bit in my Substack piece about Trooper Proctor, the termination. What does that mean? How can they do it? I talk a little about it in that piece in light of the Massachusetts case law. And Massachusetts case law recognizes this is such a broad right that you can use it to get into evidence stuff that Now I can see myself. Are we back? Are we back? I think we just had a little glitch in our signal. Everybody good? Thumbs up for me. Yay, we're back. Okay. So yes, it should be fair. It should be fair ground in my opinion. So the only other reason I can think of for trying to keep it out is that you're limited in your ability to impeach witnesses with extrinsic evidence. And meaning, can I go in and like bring in a report to show, that they were wrong? Can I bring in some other witness's testimony to show that they were wrong? You're limited in your ability to do that unless you're impeaching them on an issue that is not collateral. It is actually like central to the case. Well, the bias of witnesses is never collateral. It's not a collateral issue. It's always central. So they should be allowed to do that. Glad we got that little glitch sorted. Classical donkey. Wow, I love watching you and the face you make when explaining things and calling into question. Well, thank you. I guess I make some faces. I've had to, I don't make a whole lot of produced videos anymore. I just do mostly live stuff. Even though we spend like 9, 10, sometimes 11 some hours on the stream here, it still often takes less time than going through and like recording something and then going back and editing it. But I have done a lot of that in the past. And, when you watch yourself frame by frame for like thousands, tens of thousands of frames, you're like, wow, I make a lot of faces. Don't do that to me, guys. I mean, I know it sometimes happens, but it's just the way it is. Thank you for that. LGT, Andrea, I think your commentary is the best. And allergies in Matt are bad this year in my O. It could be allergies. I'm not going to say it's not. It just doesn't sound like it because it doesn't sound like it's a congestion or irritation problem. It's just a real harsh intake. Do the same thing sitting here. It's not like I'm having trouble breathing. It's just kind of an involuntary getting some air real fast. It could be allergies. It's an awful lot of allergies showing up in that witness chair. So maybe that's all it is. It's not people nervous. No, it could be. Lauren Boborin, I want to learn at the Alessi School of Research. The man is prepared. This man does his homework. Okay. He comes with the receipts. He is fully armed. That's what makes him so effective. He knows where he's going. He knows where he's going to get there. He knows what the purpose of the cross-examination is. It's his turn to testify. And when we say his turn to testify, we don't mean for him to characterize the evidence or argue with the witness or anything like that. It's his turn to get in the information in front of the jury that he can get in through this witness. And so he knows what that evidence is. He knows how it benefits his case, and he knows what his pathway is to get it admitted. She's either going to admit it on the stand or it's her prior testimony, so we're going to impeach her with it. And that's what he's there to do. Come armed with his research and get it done. He's a very impressive lawyer, in my opinion. Michigan Farm Boy, I've gotten the impression that Bev doesn't know much about technology, metadata, etc., based on her rulings. How much does that matter, or is this a higher level legal decision about the expert? It's the job of the parties really to educate her about the significance of the evidence that they're talking about. So, I mean, in that sense, if she doesn't know what metadata is, it's the party's fault for not educating her. And it doesn't mean that she needs to know, anything and everything about metadata, but just, a declaration from your expert about the basics of what it is, how it works, why it matters. That's really the key, is why does it matter? Could be very helpful in spelling some of that out. So you're not expected as a judge to, just like acquire expertise in any and every issue that might end up in a case before you. You can't. You can't. You have too many cases, and there's just, you know, too many things that come up, and it's not your scope anyway. Your job is not to be a cell phone forensics expert. It's your job to evaluate the evidence that is presented to you and make decisions based on it. So if she doesn't understand the significance, you got to kind of hold that at the feet of the parties for not making it clear what the significance of the metadata is. Justin Wright, look up the EXIF tool app. You can modify the metadata easily if you know what you are doing and need to justify your case somehow was used against Rittenhouse by the state. Yeah, I'm aware that you can modify metadata apparently pretty easily. You know, you apparently go in and edit it pretty easily. You can change the dates of things. You can change the locations of things. Not necessarily clear to me that unless you have that device, the device that it was done on, to be able to see that activity, it's not clear to me you would necessarily know from looking at the item itself that it's been edited. You might have to look for other clues like, oh, this has clear indications of having been photoshopped or whatever. So yeah, I understand metadata can be modified pretty easily. The extraction, the activity record cannot. At least not simply, not routinely, probably not by a, you know, relatively unsophisticated person. But a relatively unsophisticated person can use EXIF and modify metadata. Nashley 66. I can imagine what Jen told Lincoln Proctor. Told them about Karen to automatically pin it on Karen. They took Jen's words in gold. No need to look anywhere else. Well, one thing I think we do know is we know Proctor was on the group text with his phone that very night talking about Karen's medical conditions. Very limited sources of that information that he could have gotten it from. Didn't mention anything about it in Karen's own interview. Possible that came from Jen. Yeah, I can imagine. I can imagine too. We've been looking at the mean girl behavior, the catty behavior. You know, she was just one of John's randoms anyway. Enough to track a cat. Hot, you guys in the usernames, you're like right on it like that with the clever names. I feel like Charlie Brown listening to his teacher when Brennan tries to argue against Alessi. It's all false indignation and circular arguments. A lot of missing the point, not addressing the point, trying to distract. Look at this over here. Dehumanizing. For this guy to be talking about dehumanizing the experts after how he has treated the defense experts, that is hypocritical. Very much so. Confession by projection, if you will. There's nothing dehumanizing about pointing out that an expert has been wrong. Like it's just so over the top. It's so over the top and hyperbolic. It's ridiculous. But of course, that wasn't her basis anyway. She can't rely on that. He didn't give her anything to hang her hat on. So she had to run back and do her own independent research to be like, God, how can I keep this out? Oh, I know, Rule 2. Rule 2 has language in it I can rely on. Not quite so sure that that's going to work. Scorpid Black Dragon, will defense call evidence collection expert for best practices? Well, they tried to. They have Michael Easter on their witness list. Judge Cannone ruled before trial. Nope, he doesn't get to testify about police procedures and best practices and so forth because those things are in the common knowledge of the jury. And the shortcomings, those can be addressed by vigorous cross-examination. So no need for a defense expert on this. So they have one ready and available, but as things stand right now, they don't get to call him because of that ruling. Michigan farm boy, like flowers in spring, the taillight pieces bloom as the snow melts. Indeed, they do. It makes me think of my old days many years ago, working in the photography darkroom back when you actually like took, analog photos on actual, photographic film and developed the film and then exposed that on photographic paper and developed it through chemicals. Long time ago, kids. It's ancient technology back there with like the rotary phone and the CD, stuff like that. The photo, when you put it in the developer, the photo paper, it doesn't instantly appear. It takes a minute. It takes a while, but then it does. It just suddenly blooms onto the page. In the right mood, it can be a very beautiful thing to see. See that photo just suddenly bloom. Just like those taillights, just bloom. They've sat there in that snow like the developing chemical till they bloom. Ever age, if you were the defendant, how would you deal with the broken chain of evidence? As a juror, I might not understand the importance of it. So there's a couple different chains of evidence, chains of custody that we have a problem with here. I've talked a little bit about the problem with the chain of custody of John's phone. We don't know where the phone has been until it shows up. At this point in time, all we know is it showed up in Trooper Guarino's possession at some point. And we have Carrie saying, I picked it up after the EMTs lifted him onto the board and I gave it to an unknown first responder. So in that situation, what I would be doing is I would be asking every single first responder that's at the scene, did Carrie give you the phone? Did Carrie give you the phone? Which one of you is going to step up and volunteer as being the person who took the phone and then didn't handle it correctly? Didn't document the chain of evidence, didn't put it in the Faraday bag? Which one of you was it? Because if none of them step up and take responsibility for it, I get to go and argue to the jury. They've lied about how the phone got to where it was, got to the police. They've lied about who had access to it, where it was at different time frames after John was passed away. Because Carrie says she gave it to a first responder, but there's no first responder that says I'm the one that got the phone. And we don't have an independent log that tells us that. So that's how I deal with it with that situation. With the chain of custody, with the taillight pieces, all we got to point out here is that we need to track, through the testimony very systematically, who is claiming to have recovered what, handled what, etc. So we have Connor Keefe on record now saying, I'm the one who was there at the search on January 29th, and my job was to take the pieces and put them into bags and collect them. That was his job. So that means his name should be on that bag. That tape should be initialed by him. It should be dated by him, and it should be entered into evidence, if not that same day, the next day, when the evidence clerk, gets back on shift or whatever. Not having a 24-hour staffed evidence room is very much not ideal, because you want to book things in immediately. You don't want them to sit in your car or sit in a locker. You don't want that to be acceptable as a practice, that you can have delays between collecting things and booking them into evidence. Oh, the guy's not on shift. I'll just take it in tomorrow. Now your car gets stolen. Where's the evidence? So you want that to be immediate. And you just point out, it's not there. It's not there. We should be able to very clearly document for every single piece of evidence when it was found, who found it, where it was, when it was booked into evidence, who's had access to it since then. We should be able to document all of that. And it shouldn't be rocket science to have to go in and try to figure it out and reconstruct. So the fact that you have a piece of plastic of uncertain provenance contained in this evidence bag that, according to Connor Keefe's testimony, doesn't seem to belong there. He put 2 in the bag, but there's 3 in the bag. It doesn't seem to belong there. You better be able to explain that, how it got in, why it's not documented. If it broke off, you can put the pieces together and show me. You can show me, look, they fit back together. Okay, I might accept that explanation. Then they just broke. It's all from the original pieces, but you didn't do that. And now I'm going to be looking. I'm going to be looking through any other photos we get of stuff collected, pieces collected. I don't know that we're going to get any more that's going to show that piece. Really not clear. So, I mean, it depends a little bit on the circumstances. Why does the chain of custody matter? And what else do I know about it? But I mean, in general, your point is, I'm going to highlight, you don't know what you got when. And now we're back into a garbage in, garbage out scenario. Because if your analysis is supposed to depend on a certain amount of taillight plastic being found in a certain place at a certain time, but your documentation doesn't back that up, you're just saying ipsy dixit. Well, I said so. So that's what happened. And the whole point of having evidence, documentation, and collection protocols, best practices, is so you don't have to take anybody's word for it. Miss Mandy reacts. I'm Uncivil Law's producer. He wants to come up for a minute. Is possible to ask you a law question, or you come over there. He tweeted you. Thank you for this. We're obviously quite a bit past when this was happening. So I am, when I'm doing the stream, I'm not looking at other stuff most of the time. You're probably not going to be able to get a hold of me. I'm just focused on this process. But Kurt has my DM on Twitter, and so I reached out to him. He had contacted me, so I reached out to him to tell him, send me your question, and I'll see if I can answer it. Ethan Morgan, Brennan wanted redactions to the defendant's consent form. He did, and I suspect that the redactions are probably identifying information. If there's like the phone number, for example, probably stuff like that. Not terribly unusual for things like that. Might have her social security number on it. Stuff like that is not uncommon either. So. Marivi Sands. Jen gave her phone on February 2nd, according to today's guy, but wasn't she still texting about Karen Reed pleading guilty or it being a situation if she didn't then? I don't remember the time frame. I'm going to make a note. I want to go back and look at February 2nd at noon. That was a key date that that was a key date and time that Mr. Alessi elicited from that consent form. I'm going to need to go back and double check what, I caught that it mattered, but it's not real clear to me why. And so I do think that's a good question. Was there something else that she was doing with the phone after that we know about that would tend to undermine that time or that date? I don't know. I can't tell you off the top of my head, but I will go check and see if I can find anything. Sourdough Sam, Google server logs have a record of 227 search. They might. We were waiting for that last trial, right? Like, okay, you can't get it from the phone end. You can't get an answer. The solution seems very simple. Go to the server end. Go to Google. We didn't hear any Google server data during trial 1. Maybe they've done it now. I don't know. Maybe they did it before and didn't get a good result. I don't know what the answer is. But that does seem like an alternative way to go and verify the search. Enough to track a cat. Alessi just throwing in ipso facto, following by perseverate, just made my nerdy heart go all aflutter. Thank you for pointing out the Alessi words. We looked at the Jackson vocabulary yesterday. I missed the clever vocabulary that Mr. Jackson was using that caught the viewer's attention, but I definitely caught perseverate. Perseverate is such a great word. It means to kind of fixate on a topic and keep coming back to it, circling back. You're like obsessed with it. You're really focused on that, hyper focused. Maybe you're perseverating. You can't get off of it. It's a great term. That was very fun. Infoneurs, isn't this forensic expert redundant? Is duplication allowed? Yeah, in so many respects, what Hyde had to say here, it was duplicative of Ian Whiffen. It's the same thing. And so you just undermined your reasoning for not letting him cross her because of the time and delay, but she already is wasting like 2.5 hours because we're just repeating what Ian Whiffen already said. Everything about the 227, this is a repeat of Ian Whiffen. So yeah, it is duplicative. Now, maybe the defense doesn't object because they already had this plan in place for how we're going to just go ahead and turn them against each other. We're going to point out where Ian Whiffen contradicts Jessica Hyde. We're going to point out where Jessica Hyde contradicts Ian Whiffen. And with both of them, we're going to turn them into our own witnesses to provide evidence that will be helpful to our position. So maybe they just didn't object. It's fine. They have two experts, then those two experts better be in exact alignment. Because if they aren't, you get to get up in closing and be like, look, their own experts didn't even agree. Their own experts didn't even agree with each other. So what are you supposed to believe here? Mark Lyon, which hash didn't match? The internal hash in Celebrite. The process for verifying is built into the app. It doesn't require manually running hash functions. This may have been clarified for you from the following subsequent testimony. The hash value is from the gray key extraction. And the issue with it is that the hash value is provided in a PDF that is unsigned. And so because of that, it doesn't validate the time and date of the extraction that produced the hash. It can't confirm that the extraction, at least this is my understanding, that the extraction happened when the Commonwealth said it did, just that the extraction produced the results in that particular data set. All of that raw data has the hash associated with it. But in terms of when and how and by whom and everything it was created, that information is contained in the PDF. The PDF reports what the hash is, and that is unsigned. So you can't verify that. I might have that a little bit off, but that's kind of the general gist that I have. So they have all testified that the hashes matched, which, is kind of what you would expect if there was, if the implication here is that there were shenanigans with the extraction, there's funny business with the extraction, the hashes, would match, or you're giving away the whole game. So the implication, to the extent there is one, is that the funny business isn't with the hashes not matching, it's with the hash being unsigned. And so it can't necessarily be like associated with that extraction. That's kind of how I understand it. If I'm wrong, feel free, chat, just to set me right about that. I could definitely be wrong about some of those details. Guy Mitchell, I don't understand why the defense is not showing the tool mark on the tail light. They may have an expert for it. I don't know. They might bring it up with once we get into the analysts, once the actual plastic is in evidence and the analysts are dealing with it. The analysts, particularly the ones that are the forensic people, particularly the one that put the whole taillight back together. I'm pretty sure that was Ashley Vallier, but I don't remember 100%. I got the forensic experts a little confused in my mind. They may be saving it for that one. They may not be raising it. They may not be able to verify that it's a tool mark. They may not be able to verify, is it suspicious that it's there? I don't know. We have to wait and see. The opportunity for them to do that, I would say, has not been anywhere near exhausted. Jason McClellan, this digital expert is looking at the jury the most, like she is giving a lecture to a class. The defense should ask if she talked demeanor. They can ask, but I seriously doubt they did. She's a professional expert who almost had an issue for a second there. She's a professional expert, so it's probably her habit to do that. She's learned that from watching the cops and the fact that the cops do that. The cops are also professional experts, at least professional witnesses. They get expertise a lot in Washington. Super annoying, but that's just how our rules work. But they're professional witnesses. They're used to being up there, and they're often, told, talk to the jury, or they see other people do it, or they figure it out, or whatever. So I seriously doubt she was actually specifically instructed to do that. It's probably something that she already does. V Grave, why not find time of 227 search from Google? $1 million question. $1 million question. Seems like it would be easy enough to seek out, right? Now, for the defense to do it, they have to go through the Rule 7. This could, this could be a situation. Did I say Rule 7? Let me backpedal. Scratch everything I just said. This could be one of those situations where nobody is answering the question because the answer is too potentially devastating for their case. We talked about this in the Richard Allen case when the eyewitnesses who supposedly saw Bridge Guy on the trail the afternoon of the killings, they're testifying, they're in court. Richard Allen is sitting right in front of them. They're describing Bridge Guy. They're describing him as somebody who doesn't sound anything like Richard Allen. He's a tall guy, muscular. Betsy Blair said he had a beautiful, beautiful visage. Nothing against Richard Allen, but not the word I'd use. And nobody asked, neither the defense nor the prosecution. That guy sitting right there in the defense chair, is he the man you saw out on the trail? Some questions are too high risk for either party to want to ask because it would blow up your case if you get the answer you're not expecting. And if you don't know the answer, don't ask the question. So the 227 Google search could be like that. The other side is going to know if you're looking for this information. The defense is going to know if the prosecution does it because they're going to have to turn it over in discovery. Either it's exonerating and it's Brady and you got to give it up, or it's helping your case and you're going to use it. So defense is going to find out about it if the prosecution does it. For the defense to do third-party discovery, they have to go through that process. Now I'm blanking on what rule number it is anyway. They have to go through the process to get the court approval to be able to get third-party discovery. So the Commonwealth is going to be on notice that they're looking for it. They're going to make a discovery request. As soon as you get the results, you got to send them over to us. So it's a high risk for either of them. It could very well be that neither of them are going to go to Google because they can't afford the risk of getting the wrong answer. Jason Sorensen, this person is smart, but she has no skill of how to relate to people. Maybe if the jury was cats, she could relate. She just, she over-explains. She has this combination of, wanting to come off as very knowledgeable and providing like too much detail. She doesn't seem to maybe be able to read the room in terms of, am I making myself clear? She kind of seems to think that if I just explain more, it will become clearer, but I don't know that that's the case. I think that can be a common issue with people who are really smart, aren't necessarily great communicators because they can't necessarily relate to what a less smart person might think or understand. And so they aren't necessarily able to translate their own thought process into one that a less smart person could understand. I think there's a lot of different kinds of intelligence. I'm not sure if that's really like an emotional intelligence or like a relational kind of intelligence. But I agree. I can't say that woman was a good communicator. I can't say Jessica Hyde is a good communicator. It's very unclear. She runs on. She's very rapid fire, throws out a lot of technical language that she doesn't define. She's not consistent with her use of terms. I don't feel that she has a sense of how to simplify some of these ideas for people who may not be as smart as she is. Daryl Smith, why don't they just get the internet activity logs from the ISP? That would show what exact time the search request was sent to the servers. Yeah, ISP potentially another source for that. I don't know if they would maintain that record or not. I'm not that familiar with records you get from the network, but they may have a record. They may have a record of it as well. Same reason, it just might be a little bit too dangerous to go ask. Nobody really wants the answer. We can both make our arguments based on the phone extraction and what we think it says, but one of us is going to have our case blown up if we go to Google or we go to the ISP, and maybe we don't want to run the risk that it's me. Now, if Jen McCabe is absolutely insistent, I did not do that Google search at 227, wouldn't you, as the Commonwealth, then be like, okay, let's go get the Google search? But unless you already suspect, maybe I shouldn't believe what Jen McCabe tells me. Little food for thought there. Summertime, does this mean anyone who's been convicted in part due to a Google search will now get a new trial en masse? Because they've just told me Google is bad. I don't think it's as broad as Google is bad. I don't think it's as broad as Celebrate is bad. I do think it raises some questions about when you are testifying about these Celebrate reports and what they report, how reliable is that? Most of the time, the testimony about these issues are not coming from an adjunct professor at George Mason University or people like that. They're coming from law enforcement. They're coming from folks like Trooper Guarino, who's taught to go and use Celebrate and make reports from it. So all that testimony she just gave about how relying on the report alone is problematic. You need to be able to understand and independently analyze what the meaning of the artifact is and so forth. The police officers are not trained to do that. It would be, I suspect, a pretty rare police officer who has that kind of training and understanding and expertise. They get the Celebrate report, they read it, they testify about it. And so, yeah, I think potentially a lot of that is undermined by this, or should be. Should be. Do you understand this artifact? Do you understand the file structure, the data structure? Do you understand? Did you do any testing, to validate this process? I mean, I feel like they've just opened the door for how Celebrate in and of itself can't really tell you anything. You have to go in and interpret it, and that just rarely happens. At least from my perspective. I've never had somebody like a Jessica Hyde testify in a case about a Celebrate extraction. I've seen an awful lot of Celebrate extractions and cases. And it's just, here's the report. I went through the report. I picked out the important stuff. Here it is. So I think there are some implications. Yeah. I don't know if they're as broad as Google is bad, but could be as broad as the normal practice, what you typically see with how police officers testify about what's in Celebrate reports. That's bad because the data could be unreliable and could be ambiguous, and you may not know the meaning of it. Jason McClellan, how long to die from Raining Men video? Yeah, the Raining Men. We're still hearing about that one. Heard about that from Ian Whiffen. Doesn't match the history information. Doesn't match the time when Jen McCabe was saying She had that on her phone. She had that story. You know, we played it that evening over there at John's house, or over there at Brian and Nicole's house. Because it's a joke. It's a joke about It's Raining Men. It's a family joke. So we shared it. Not according to your browser history, according to Ian Whiffen. According to Ian Whiffen, you searched that on January the 26th. And the only reason it came up is because you brought that tab forward and then closed it. Alessi's big brain to free Karen Reed. She may be clever, but she's giving me American Pie vibes this one time at band camp. Well, she's an expert on everything. You know, seen everything. Smartest person in the room. Jason McClellan, TMI, too much information. It got a little excessive, didn't it? It was too much. If you simplified it and were able to make it systematic and clear and orderly, it would probably be easy to swallow, but you need to do that by slowing down, defining your terms, and then using them very carefully. You just don't run through all the, associated with the wall file and the browser state.db and the write ahead file. And it's like chicken and waffles. And then the wall file, like you haven't even told me that the write ahead log is the same thing as the wall file. She never spelled that out for the jury. I know that. I don't know if any of them know that. So she starts using these inconsistent terms. The jury doesn't know that. They're lost. Any one of the jurors who doesn't know that, they're lost. I don't know what we're talking about. What's a wall file and where did that come from? And why are we talking about chicken and waffles? I agree. Too much information. My mini 67 butt dials. Help. Just got back from a hospital appointment to find a 7th century Dutch housewife explaining how her software gives another search time, like an accountant that can make 2 + 2 = anything you want, sir. She, to her credit, was not Ian Whiffen. She does not have her own software. Ian Whiffen is the one who has software that can plug into the phone and make the phone do what he thinks it should. It will show the phone doing what he thinks the phone should be doing. He has written software that does that. She didn't do that. She was much more vague about what her testing was. Just that she did testing. She did testing to validate. I don't care about how she looks. You know, I notice, I don't care. I don't care about stuff like that. How people, I don't think that stuff matters. Now I notice when there's changes. I notice when you make some expressions. I notice when you get flushed. I notice stuff like that. But I don't care. I don't care about her hair. I don't care. Amelia Walsh, am I crazy? But if they were all Googled after 6 a.m., are they suggesting Jen opened a new tab after she did Haas Long? If the Commonwealth were doing a good job, you shouldn't have this question. I kind of think that's the bottom line. If the Commonwealth was doing a good job, you shouldn't have this question about what all this stuff means. It would have been clear. They would have made it clear. What I understood from Ian Whiffen's testimony is that their theory is that the reason the tab has a timestamp of 227 is because that's when she created the new tab. So that's when the tab was opened in Safari. She then did whatever she was going to do in that tab. And ultimately at 6:24 in the morning, she Googled Haas Long to die in cold. She then closed that tab. And the closing the tab is what causes the phone to register the browser state.db entry. But it reports the last activity on that page associated with the first time that the tab was created. That's their theory. That's their explanation, as I understand it. That it doesn't reflect the tab and what it did when it was created, what it was on when it was created. It's the last thing that happened to that tab before the tab state changed. That's their theory. So it was closed, backgrounded, phone shut off, something like that was what Ian Whiffen testified. But you shouldn't have that question. If they were doing a good job, it should be clear what this all means. WW, Hyde, how the ever-loving F does this prove J.O. was hit by a car? Well, it sure doesn't, does it? We're so far, like this is Hank's version of the pre-Buttle case, right? He's not so far calling in every single one of the people in the house at 34 Fairview to let them give their story and so forth, try to preempt the defense, bringing up all the shady stuff. He's not doing it quite as bad so far as Lally did, but this 227, this is pre-Buttle, because he knows that's a very bad fact if the jury hears it and believes it, that Jen McCabe, there's some indication on Jen McCabe's phone that could suggest she searched Hoslong to die in cold at 227. That would indicate guilty knowledge. The jury can't get that impression, so he is pre-butting it. It doesn't prove John O'Keefe was hit by a car. It's trying to rebut Jen McCabe having guilty knowledge that would tend to probably destroy the Commonwealth's case, if not seriously cripple it. Under their whole version, none of these people should know. So, the ghost of Brian Higgins' SIM card. Can the defense just get someone from Google to confirm whether the search was conducted? If so, why wouldn't they do that? So same answer. They probably could. They'd have to go through that. Why am I spacing on the rule? Whatever rule it is in Massachusetts that they have to go through for third-party discovery. And it just may be too high risk for anybody to want to get a definitive answer on that. Somebody's case is getting destroyed one way or the other, so nobody's asking. That's my theory. Mimi Supertini, Hyde, timestamp is when tab goes to background, within when tab comes into focus. And ultimately, Hyde, we have no idea when the timestamp is. We really don't. It's inconsistent. It could be anything, really. We have no idea what causes the timestamp. Great. And with that clarity, are you closer to understanding whether Jen McCabe searched Hoslong to die in cold at 2:27 a.m. or not? I am honestly not even sure why they called Jessica Hyde. I'm really not. It seems like it may have been smarter to just stick with Ian Whiffen, or if you're going to call Jessica for the purpose of the deleted calls, just call her for that. I don't know why they went down this road. I don't think that was particularly helpful. Shards of words. DoorDasher just asked what the fuck I'm listening to. Well, we all have different tastes. I'm sure they've heard stranger things showing up at people's houses. I can imagine. My Mini 67 butt dials, consensus-based is not fact. Sloppy. Yeah, it was consensus-based for a long time that the sun revolved around the earth, wasn't it? Consensus-based, because that was the official position. That was the orthodoxy. And you depart from that, you might get burned at the stake, but it's not a fact. People quite often believe stuff that is actually wrong. Illness isn't caused by, God, what was the word? Not miasmas, but something like that, like bad air. It's bad air that made people sick before we understood germ theory. Bad air, you got to be bloodlet. I've told the story before about how there's a little bit of truth to bloodletting. It's because after the Black Plague, people who had the gene for hemochromatosis, which is a tendency to overaccumulate metal in your blood, specifically iron, they had greater immunity or protection against Black Death, Black Plague, than people who didn't have this gene. But it itself caused separate health problems if you get mineral buildup in the blood. So after the Black Plague, then that meant there is a higher percentage of people in the population who have the gene for hemochromatosis. And bloodletting actually would be a little bit helpful if you are suffering from these issues of metal accumulation, because you just let some of the metal out. It did actually have some kind of basis to it. just not for the reason they thought it did. Anyway, that's totally aside. But yes, consensus is often mistaken. Danielle C., trust her because she supports her own work. I really mean it, guys. I swear. I teach this stuff, so it must be true. Has teacher ever taught you anything that's not true? No, of course, that would never happen. How could it? How could it? It's taught, therefore it's right. Truth be told, you are getting a free legal analysis from an appellate attorney. Hit the like button. Well, thank you so much for that. Just sharing what I know. Just sharing what I know, what I've learned over the years, what I've learned from experience. And it's wonderful to know people find that helpful. So I appreciate that. Sentient Dreamer. In situations like court, humans look to the authority figure to determine what's worthwhile. Bev's deliberately making the defense look bad. Jury will note this, and it's inappropriate she's doing so. That comment she made last time, Mr. Alessi, when he asked for the sidebar, yeah. Yes, indeed it was. Because that clearly communicates you're wasting my time. I don't like you doing what you're doing. I don't want you to do it anymore. I'm giving you grace by letting you do it this time. Not the kind of things you should be communicating to the jury, and exactly why she had to come back and give that little mea culpa to the jury after the break was over. If I get frustrated and say things, don't take anything from it. I shouldn't. Attorneys are just doing their jobs, but we want to have not very many sidebars. So then she doubles down. Then she doubles down. My frustration was justified. She doubled down. She undid her own curative instruction. Not Jessica Hyde isn't the only person in that room who really needs to be right all the time. Can't even acknowledge, oh yeah, that was bad. Fall on my sword. Shouldn't have done that. Jurors disregard it. Period. Unequivocally. Disregard it. And the judge, we've talked about that before. The judge has enormous influence over the jury. The jury, typically speaking, they are going to look highly on the judge. They have a very high opinion of her. She's the one that the only one that can address them directly during all of this, during court. Until we get to the opening and closings and stuff like that. She's the one that tells them the law. She's the one that's up there in charge of everything. She has a lot of influence in that courtroom. So her putting her finger on the scale has outsized effects, or it can. Stormy, judge needs to apologize to jury and tell them that was inappropriate of her for saying that, in my opinion. Well, she kind of got close. Like she was sort of saying it and then kind of took it back. Certainly didn't say, I'm sorry. We didn't hear those words. She did say, I shouldn't get frustrated. No, you shouldn't. But frankly, even if you are frustrated, what you really should not do is express that verbally. You really should not do that. You can get frustrated in your own mind and your own inner life as much as you want. That in and of itself is not a problem. It's what you're communicating to the jury that's a problem. They're inclined to follow your lead. So if you're frustrated for the defense, they're frustrated by the defense, they're likely to think defense is doing something bad. Bad inference. My mini butt dials. Scientific certainty means it is A, documented, B, repeatable, C, reliable, D, tested by another party to achieve the same results. This is disgrace. It should be at least replicable, if not actually replicated. It should be verifiable, meaning I can go back and look at what you did and look at your sources and things like that. It should be objective, not something that is just, my opinion, my subjective. Well, I think that there's sufficient certainty, sufficient agreement between the marks over here on this shell casing and the marks over here on this thing I fired out of the gun for me to say it's from the same gun. What's sufficient? Well, whatever I think it is. It shouldn't be that. That would not be scientific. Certainly not according to the Abrukwa decision. But yeah. Yes, these things all should be. It fits some of those. I mean, they can all rely on the same data set, right? Defense expert can do the same. They can rely on the same extraction. They can use the same tools. But I would hope that there would be full disclosure of her, her methods and what she used, and if they needed access to her computer or whatever, that they could get it. We were reading that decision from Maryland that Brandy found when we came back after the break, and none of those things were available, and that was a problem for the court, as it should be. Because if you're not willing for your work to be reviewed and validated, it's not particularly scientific. Infonurs, not to be petty, but the uptalk of Hyde is just grating on my nerves. Is that it is correct. Correct. It's like she's talking to a child. Or a puppy or something, something not intelligent, something that you're just trying to appeal to on a very base emotional level, communicating, I'm friendly. I'm friendly. I'm the good guy. I'm not here to hurt you. I'm good. Okay, but we care about the substance of what you have to say when you're an expert. I found it condescending. Particularly then when she goes and focuses that on Alessi, it's just so out of place. So out of place. iReactor. Scientific degree of certainty is not a thing scientists say. Can we get a Bonsai update? This is so true, and this is such an underrated point. There's no such thing scientifically as a scientific degree of certainty. If you want to talk about a scientific degree of certainty, what you're probably talking about is standard deviations and error rates. That's what you would be talking about. You can be certain within, 1 standard deviation, 2 standard deviations, 3 standard deviations, whatever. You can define how certain you are, and you can establish, percentage of the time that doing your process exactly the same, you would still get the wrong result. You can define an error rate. That would be how scientists would talk about science. These whole magic words that they use in Massachusetts, I'm not actually convinced it is a magic words that you have to use in Massachusetts thing. I kind of suspect this might be a Judge Bev thing. That's her. You got to use the magic words for it to be admissible. I don't know. But I agree. It's so ironic because the whole concept of a scientific degree of certainty is not scientific. That would be subjective. Josh H., how was the 623 search a Google suggestion if it had never been searched before? I think what she's saying is that if Jen was starting to type into the search bar, how long to die in cold, how long T die in kick D or whatever, that as she's putting in the words, it brings up, how it'll bring up in the search bar, the rest of the sentence. And then you can hit, I think it's usually tab, and it'll accept that suggestion, or you just ignore it and keep typing whatever you're going to type. I think that's what she's talking about, that it comes up once you start entering that search as a, it's trying to complete your words for you, complete your thought for you. But she didn't spell that out, did she? That's me guessing. It's me guessing. But she didn't say that explicitly. Clever nickname. How long to order waffle pizza? Waffle pizza sounds good. That sounds good. I've never thought of that. That actually sounds really good. Belgian waffle pizza. That's one of those things you eat once and probably never eat again because you regret eating it. But also you just you cherish that memory. Waffle pizza. Stephen Huth, can we get a wellness check on the court reporter? The court reporter had to do some sprinting today, didn't she? Trying to keep up with Ms. Hyde, and then Mr. Alessi also, gets excited and starts talking real fast. She was in sprint mode for a lot of day today, so I hope she gets some good rest tonight, some good recovery. It's good to work really hard, very high intensity, and then recover from it. That's some of your best fitness comes from stuff like that. Jason Sorensen, this is way too complicated to be true. I don't know. I really don't. just it seems like it should be clearer and easier to articulate if it's that easy. But the bottom line seems to be she can't say. She can't say what happened to the tab. She doesn't know where the timestamp came from. Like, we had a lot of talking around what seemed to be the fundamental opinion. I don't know. That's the bottom line. A lot of talking around, I don't know. I believe I don't know is true. If we'd stuck with that and be like, great, me neither. I'm on board. So I don't, all this going around, I'm not sure how that works. Sweet Lorraine, Whiffen said raining men happened the day before. Pretty sure he said the 26th, but yeah, it could have been the 28th, but it did not happen. The search didn't happen. And he knew that. Why? Because of the history. The history.db, it's in, oh, you mean that was in her Google search history? But Hoslong to die in cold was not, is what Ms. Hyde told us. Huh. Interesting. Interesting. A cool breeze. Read, Jessica Hyde's testimony proves that the Commonwealth is defending McCabe rather than prosecuting Reed. Obfuscation at its worst. Obfuscation by using a lot of words to cover up the fact that I don't know is your ultimate conclusion, but you want to suggest you do. The only thing you know for sure that you testified to a reasonable degree of scientific certainty, magic words, whatever that's supposed to mean, is that the search happened at 6:24, but you don't actually know anything about whether it was searched before. You don't know. It's not in the history anywhere, even where it should be. If we did the search at 6:23, 6:24, and didn't delete it, didn't try to cover it up, wouldn't it be there? If It's Raining Men was there. Pre-Buttle case. Got to get out ahead of that because it's such a bad fact. Josh H., how can she testify how anything on an iPhone works if she has no access to Apple's source code? Well, didn't you hear her? That would be a terrible source of information anyway. It's zillions of lines. It'd be a terrible source of information. Because she relies on Celebrite and Axiom and all these other tools to do the code interpretation for her, to at least make sense out of what data is the phone reporting. And then they go back like through the reverse engineering process to try to figure out, can we like reconstruct this phone architecture based on the results? It's kind of like the difference between I'm going to design Hoover Dam myself in my mind, and I'm going to create the blueprint, and I'm going to give that to Bechtel, and then Bechtel is going to go out and construct it. That's the code side. Versus I'm going to go and look at Hoover Dam, and I'm going to study how it functions. I'm going to see what I can in terms of here's the size, here's the shape, here's the internal pieces, here's the hardware, and so forth. And I am going to recreate the blueprint for Hoover Dam based on my observation of the actual Hoover Dam. That's the reverse engineering. So it's basically that they're trying to do that, and we're to take it on faith that they have it right. We're to take it on faith that they have it right, that their processes protect it to make sure that it's accurate and reliable and so forth. But apparently, not all that well. If Celebrite's reporting stuff that is unreliable for at least a certain amount of time, and people are getting confused, so they take it out, but Axiom still reports it. I mean, the artifact is the artifact. Your inability to understand it doesn't impeach the phone. It impeaches you and your process and the limits of your reverse engineering. So that's what they're doing, and that's the basic difference between it. Hopefully that was a little better example than chicken and waffles and pizza and all that. The words, Alessi needs a break to go through that word salad. I don't think Alessi needs a break. I think he knew every word as it came out. I don't think he was shook for a second. Edward Kirkpatrick, just scrolled 200 plus call logs in recent call tab back to December, and my phone is still loading more as I scroll. Well, maybe you have a different iPhone, different iOS. I don't know. I don't know the answer to that, but, Jessica Hyde said so, and it went unrebutted. We'll see if the defense expert has something different to say. I know a guy, if you order pizza and then decide you want waffles, Jen didn't search Haas long to die. That's funny. It was just very confusing. It was very confusing what we were talking about and how this example relates to what is happening. And I think it's like maybe because she can see in her mind this is how the process in the phone unloads or unfolds, and here's the file structure where it shows up in different places and stuff like that. But the jury doesn't understand that, so I don't think they have a very good frame of reference for what's in the server window, what's at the table. What about when the order is made? Is that a separate thing? It's just very confusing. SanDB, no explanation of it actually existing in the exact spelling being in that phone and deleted. If it didn't happen, none of the experts would have found it. I don't know if it actually existed in the phone, spelled correctly, or just the Haas long. Why it's marked as deleted. She said Celebrite marks things as deleted if it's not in the place where you expected it to be. Like where? History.db? Still not real clear on why this Haas long to die in cold is the only one of these tabs that shows up with the timestamp as deleted. Ian Whiffen couldn't explain that either, but he went through a whole big theory about the tabs and the tab states based on, his review of when it was brought forward and deleted. And so the It's Raining Men has the browser state.db timestamp of 2:25 or whatever. But from the history that it was searched back on the 26th or the 28th. I'm pretty sure it was the 26th, but I could be wrong. Was it marked deleted? Was it not where it was supposed to be? Why is only the Haas long not where it's supposed to be? None of them have been able to explain that and reconcile it. So that's a problem for me, as I consider myself a reasonably intelligent person, listening to what they're saying and trying to learn from it, using my own personal experience and so forth to try to make sense of it. They have not explained that. So it remains sus. Ian Whiffen can't explain it. She says, I don't know where the timestamps come from. So why did you get called? I don't know. Jason Sorensen, this shouldn't be so hard to explain. She really comes off as someone who had a conclusion and worked backwards to find a way to justify her BS. Could be. Could be. She could just be a really bad communicator. I don't know. But it does seem like it should be simpler. To the extent that she and Ian Whiffen were, in fact, they have the same theory, they're describing the same thing. To me, Ian Whiffen did like 1,000,000 times better in making it understandable. The browser state timestamp, the browser state.db timestamp relates to when the tab, there's action relating to the tab. It's brought into focus, it's brought into the background, or it's closed, or the phone is shut down. He made that, I thought, very clear. She did not at all. She did not make that clear at all. Coach Platitude, parentheses, Coach Platitude. I'm a SQLite developer. These search anomalies smell like a third-party tool did the deletions manipulation, breaking normal connections / links. That's very interesting. That's very interesting. I don't know. I appreciate insight like this from people who have much greater knowledge and experience with things like programming than I do. I know next to nothing about programming other than that there's code. There's different ones that you use, and some you know and some you don't. I remember my dad was into Linux for a while. I think might still be. Might have like some like super old, can't be updated. You know, it's no longer supported on Windows or whatever kind of computer. So he's running it on Linux. It's about the extent of my knowledge of how programming works. So I will take your word for it that it smells like a third-party tool did something. Be good, be safe, be happy. How is there blood in the snow if hit before snow fell? $1 million question. $1 million question. How are there droplets of blood on top of the snow if John is supposed to have been lying on the ground since approximately 12:30 the night before when there was no snow on the ground? That's the $1 million question. We'd all love to know. Doesn't make sense to me. I am hoping for and kind of expecting the defense's experts to be able to explain that, perhaps the pathologist. Because yeah, if he's been lying out there since 12:30, he's dead. He's not actively bleeding anymore. The blood should have congealed or it should have frozen unless he literally died like seconds before. And that seems pretty implausible, doesn't it? That'd be quite a coincidence. John lays out there for 5.5 hours, but at 6:02, he takes his last breath. You know, blood stops pumping, but there's still enough like in his nose or mouth or whatever that when they come and they move him, it splatters on the snow. It's still in a liquid state. That would be a pretty big coincidence. And I don't know if that would explain his 80-degree temperature. So I'm kind of hoping for more elaboration on this when we get to the defense case. Little GTO, not sure if asked, but how did blood get in the snow if there was only a dusting when alleged waffling happened? $1 million question. And where's most of the blood? Why do we only have a couple droplets on top of the snow when we should have a massive puddle from the back of his head that we now know from the Commonwealth's own weather guy would not have been able to penetrate the ground. The ground was impenetrable, just like Lally's mom. The blood did not seep into the ground if the ground is frozen. So where's the rest of the blood? Where is it? Why do we just have a few droplets on top where it's not even supposed to be? The crime scene is not consistent with their theory of the case. The Commonwealth has the obligation to explain that. And I think what they're doing is just ignoring it and hoping it gets overlooked. So I expect the defense to not overlook it. Teddy Bear 1287, just to be an obnoxious geek. I love obnoxious geeks. Most of Safari is actually open source. This is actually about how Safari interacts with the database on the phone. Thank you for super geeking that. I love it. I don't know. Safari is open source. So that suggests that you might be able to write code that would affect Safari and potentially how Safari interacts with the rest of the phone. Right? If you have open source access to Safari, you might be able to write a program that would change how Safari gets the information into the database. Am I correct on that? Wouldn't be as tricky as getting access. You wouldn't have to necessarily be an Apple developer to do that if you needed Apple source code. I love obnoxious geeks. Thank you so much for sharing that. I love learning stuff like this. Josh H. So Whiffen and Hyde's testimonies conflict apparently in more than one area. There were a few conflicts that got pointed out. The ghost of Brian Higgins' SIM card, notably absent. Congrats on your career up to now. Yeah, I didn't congratulate her on her career. He doesn't have to do that. That was not a necessary aspect of the battle of politeness. Melissa Mathis, this may just be my opinion, but I feel Auntie Bev has a soft spot for Alessi. She treats him, talks to him, etc. differently from the others. I don't know if she has a soft spot for him or if she simply respects him a little bit more because she has a higher opinion of his technique. We just watched him go through an absolute pristine textbook cross-examination with impeachment, with refreshment, all of that stuff. Did it 100% by the book, the way that you're supposed to. And there's no issue. And she gave him some of his objections. It's clear what they are. You know, she trusts him to get it on these details in a way that I think she may look down her nose at Mr. Yanetti and Mr. Jackson a little bit. She doesn't have that kind of respect for them. When Mr. Jackson did it like Mr. Alessi has been doing here today, did it textbook like that. Let me read you verbatim your prior statement. Identify where it's from. Do you deny it? Make it clear where we're going with this particular statement. Then she's cooperative with him too. So that's kind of my read on it. If she had a soft spot for Alessi, I don't know that she would have ran back into chambers and been like, how on earth do I justify not giving Mr. Alessi what he's asking for? She would have bought his argument. I mean, it's a good argument. From my perspective, it should have controlled. Her basis is not well-founded at all. It's not the rule that you'd look at in this situation. Maggie Beth, I love how polite Alessi is while he's destroying people's egos. He's a smiling assassin. I love this style because yes, this is your facts or your fists. You don't have to feel any particular way about it. The facts just are the facts. And so I can be extremely polite while I'm pointing out to you that all of the facts tend to contradict what you just said on the stand. You don't have to be mean or angry about it. It's just facts, just business. I find it very effective. Kyle Byers, 11:23 a.m. UTC is 7:32 a.m. EST. So that's a 4-hour difference. I would bet that it depends on whether we're in daylight savings time or not. Are we in EST right now or EDT? I think we're in EDT. So we sprang back. No, we sprang forward. So it would be 6, sprang forward to 7. I can't do that in my head. That's disorienting. But that would be my guess. Maybe the discrepancy between standard time and daylight savings time, possibly. I don't know, Kyle, but didn't come out any further in Cross, so don't know if we'll hear more about that. Abacus Flinch. This is for my snacky and pat on the head. Thank you. Thank you. I appreciate it. Thanks for that. I try not to talk to people like they're idiots and like they need a snacky and pat on the head and put down to their nap. Unless I want you to know I'm talking to you that way, then I might, but that's probably pretty rare. You know, what's the point? What's the point? Usually information speaks much more loudly than tone and attitude and stuff like that. Sentient Dreamer, court should have granted Alessi's motion this AM. I agree. It should have. It goes to her reliability and her basis is not good. Jason Sorensen, this is what it looks like when someone who is used to BSing people runs into someone smart enough to call her out. Oh, she was scrambling and getting hot, wasn't she? And getting extra snarky. She thought she had this in the bag. I'm the smartest person in the room. But then you met Robert Alessi. And it had to cross your mind that maybe you're not. And then he pointed out that you were wrong. The affront. Oh, she held that against him very, very much. She held that against him, pointing out that she was wrong. The problem is not her being wrong. The problem is him pointing it out. Alessi's big brain to free Karen Reed. Smug Girl reminds me of Dr. Spiegel from Depp Case squirming about in the facials. I didn't catch her doing like the bad gurning that Dr. Spiegel did. I mean, he was such a special case. You know, I think you could go your entire life and never see a witness quite like that again. It was just bizarre. So I can't say I see her being that bad. And frankly, Connor Keefe was very bad with the facial expressions, tight beaker face and stuff like that. I didn't really notice that nearly as much with Jessica Hyde. I did notice a couple times the narrowing eyes and the, trying to follow, like not sure where he's going. But the whole active gurning thing that Spiegel did, I don't think it was that bad. That was just weird. That was weird. Nobody special. Did she just open the ability to show additional location data based on her testimony? I don't know if there is additional location data or that they would need to open the door to do that. The defense is going to have their own phone experts to be able to testify about what's in the phone. If you're talking about like other sources of data, location data, besides what they maybe got from the phone, like for example, I don't know, geofence data or something like that. I didn't hear anything in her testimony that to me, tended to clearly open the door to something like that. When Brennan was trying to get into location stuff, that's when Alessi objected. It's beyond the scope. Those were sustained. So they were never able to get into that. So if that's it, the door was never opened. Zoo Blues has gifted a membership. Thank you so much for that, Zoo Blues. Appreciate your support. Josh H. Last movement of the phone 003216. Karen connected to JOK's Wi-Fi at 003639, 2.3 miles away. Yep, just slightly over 4 minutes later. So 30 miles an hour the entire way. We think she was doing that. I kind of doubt it in the storm. Not after how, especially not after how Ryan Nagel and Heather Maxson were describing her driving. Signals on, 10 and 2, going slow. No, I don't think that is going to add up. Phil, the Gilbert villain Biggs. Demand, Fed, investigate. Sirens as Alessi crushes. The sirens are just an ongoing presence, aren't they? He hadn't really got started when that big rush came through. And frankly, I enjoyed his patience with it. He found it a bit amusing too, doesn't he? What a remarkable coincidence. This massive sirens just as I'm getting up to start my impeachment, ask my question. That's okay. I'll wait patiently. Some of us can wait to talk. Wait until it's our turn. I don't know if there is any significance to the timing. Perhaps somebody is tracking that. Clinton Hall, yesterday wrapped up early with Aunt Bev informing the jury that we are ahead of schedule. Today, staying on track is her excuse. Jury must be, Today, we go home early because we're still ahead of schedule. We're on track, at least on track. We're where we need to be. Who knows what the jury is thinking at this point? Shards of words. Before I go, shout out to minutes of sirens with Zen. That was a very long siren on that one. Very long, very loud, right there during Mr. Alessi's cross-examination. SM, guess Commonwealth can subpoena Google for 227, probably get JM consent as she insists she never did, but I think they don't want to look under the rock. I agree. They don't want to look. If she was insisting I didn't do the search at 227 and they believed her, then you would corroborate it because that would only help your case. So the fact that they are not seeking to corroborate it seems to mean maybe they don't believe her denial. Mike, defense did much better with and Hyde this time. Last trial, I remember being baffled, even thinking the Commonwealth had the edge. Not this time. If the standard is reasonable doubt, the Commonwealth has a big problem. I agree. I thought it was clearer. I thought it was handled better. I thought the problems with what they were doing and the limitations of what they were doing were made a lot more clear. The inconsistencies in what they were pointing out were a lot more clear, and also the ways in which the data helps the defense. Part of that, at least with Whiffen, is like they expanded the scope. The Commonwealth kind of expanded the scope of what he testified to this trial. In the first trial, a lot of that stuff about like the location and so forth, pretty sure that came out with Guarino, just from like reading the Celebrite report. This time they handed it over to Whiffen, and I'm not sure that that helped, because it just gave the defense more areas where there are problems with the evidence to be able to, cross-examine on. And that may tend to undermine the weight that the jury is going to give the stronger part of your testimony, which is, your theory about your explanation for the 227 timestamp. So if the jury thinks, you're off with your techniques and stuff because of other stuff that you were doing, maybe they'll call into question that also. But what it kind of looks like, I don't think they spelled this out with Whiffen, but obviously they did with Jessica Hyde. They went back after the first trial and made new requests, and so I'm reasonably certain they did that with Ian Whiffen too. Okay, try again. Do more, follow up. And that may be part of the reason why we have this new data about stuff like, the lock button on the phone. I don't know for sure that this originated from Ian Whiffen, but he's the first person I've heard testify about it. Same thing with the 507 call between Jen McCabe and Nicole Albert. First time I'm hearing about it is in this trial. So South Texas, she's Catherine Arnold 2.0. God, I know Catherine Arnold. I'm going to have to Google real quick because I can't remember off the top of my head who that is. Was she Amber Heard's witness? I can't remember now. I'm sorry. I got too many things. It's a pinball machine up here sometimes. Just stuff getting knocked around and finding itself in strange places. Can't remember who Catherine Arnold is. Josh H., I want to know how many interactions John's phone had from the time of death until its extraction. Did someone do anything on his phone? We know it started moving. Other than that, I'm not sure if we know more. Jessica Hyde obviously stopped at noon. I don't know. I will be very intrigued to find that out too. We haven't heard anything so far other than the phone moving around, acquiring location data. Nothing that's necessarily a user interaction other than the moving. So we'll see if more comes out. Stephen, is this Huth or Huth? I'm sorry, I don't know. I'm going to guess Huth. How is this evidence admissible if chain of custody cannot be established? So you typically have to establish a general, kind of broad chain of custody for it to be admissible, which is typically by the person on the stand who's identifying as this is the thing I collected and I put in. So like with the taillight, for example, I'm pretty sure that's how that's coming in. It's not a super high bar. And then, issues with it relating to that go to weight. But normally you're talking about like, I have a clear chain of custody of how it came into evidence. I don't know that I've ever seen a case like this because most people are better with their evidence handling. They don't have stuff that's collected by one person on one day and then booked into evidence by somebody else on a completely different day. I have to assume the defense has raised chain of custody objections. It seemed to be what they were doing with the sidebars when there were the objections to that evidence coming in. Seemed to be based on chain of custody. And that seems to be overruled, or at least, she's satisfied with the showing so far. It's an evidence. He says it's what he collected, therefore it's good. Yeah, I don't know about that. Monty Sliv, parentheses, Monty Sliv. Kerry Roberts say he lived on Meadow, not lives in the call with Sergeant Good. I'm not sure. We haven't heard from Sergeant Good yet. Oh, you mean the call that she made at like 5 a.m? Did she say that? He lived on Meadow? I didn't catch that if she did. Could be a transcript issue. Not sure how clear the original phone call is. I'd expect it to be pretty clear, right? I'd expect it to be a record from the emergency, services, the dispatcher. Actually, I guess, we learned Canton PD does their own dispatch, so I'd expect it to come directly from them. Should be a pretty clear record, not the booming, echoing stuff that we hear when it's played live in court and then echoes around the room before it's picked up by, microphones in different places. If she said he lived on Meadow, that's maybe a slip. I don't know. She didn't get confronted on it. We know that. Debbie Lynn F is a new YouTube member. Welcome to the channel. Kitty Carey with a super chat. Thank you so much for that, Kitty Carey. Appreciate your support. Nenny, what if Commonwealth doesn't call Higgins, McCabe's, or othered Alberts? Then the defense will decide if they're going to call them themselves, and they're going to have a strategy, I would expect, for how to handle that in their closing. If you also choose not to call them, maybe then we raise the issue of these people are available to the Commonwealth to, answer questions, to resolve discrepancies. They chose not to bring them in. The defense calls them. You can be like, why did you have to wait until our case in chief to hear from Brian Higgins? Why did you have to wait until our case in chief to hear about these weird records of communication between Brian Albert and Brian Higgins? If the Commonwealth was interested in you having a full and fair picture of the facts in the case, wouldn't they have put that in first? Why'd you have to wait for us to do it? They'll have a strategy. Because I would expect they've kind of game planned this. At least I would hope that they have. The possibility if they don't get called, you always need to have that in mind because, okay, the guy is on their witness list, but there's no guarantee that they're going to get called. So do you need information from this witness for your case? Do you have a backup plan if they don't get called? They're all on the defense witness list, so the defense can call them. I would expect they have already made a decision, or at least have a general idea about whether they will call these people themselves. And frankly, yes, I think they would. James Casatelli, I wonder if Bev feels embarrassed when she tries to hobble Alessi and then he destroys the witness. He's great. I want him to fight my parking tickets. You pay so much more for him to fight your parking tickets than your parking tickets are. You know that. But it would be fun. It would almost be worth it, wouldn't it? Just watching him do it. He is. He's fantastic. I'm a big Alessi fan. He's just technically very skilled. I appreciate he may not be the showman or the storyteller that other lawyers are. But just from a pure standpoint of being very smart, very prepared, and knowing how the courtroom works and what the rules are and how to operate within them, knowing what his pathways are, what his options are. I've got a backup plan, all that. He's top notch. I think he's an excellent lawyer. Rob Inson, on the plus side for the Commonwealth, nobody will believe a Massachusetts cop has the intelligence to modify EXIF data or SQLite databases. Could be. Could be. Nellie Wood. Karen was diagnosed with Crohn's disease at 25, had to use a colostomy bag for a while. Super classy for anyone to make fun of, let alone law enforcement. Shame. Yeah, this is going to the Trooper Proctor group texts to his friends the same night that he's gone to Karen Reed's home, seized her car, etc. And he's talking about, no shit's going to come on the homeowner because he's a Boston cop too. Also making some rather disgusting comments about Karen's appearance, medical conditions, sexualizing her, doing some pretty gross stuff. And we're going to, I'm sure, hear all of those details again soon enough. Andrea McBurnett. Matt's last text about the plea was after 5 p.m. and a couple hours before Karen was arrested. Yeah, she hadn't been arrested yet. I think I'd seen folks point out this problem with the timeline. So if she takes a plea, how do you know that's even on the table? Why? Because you've been running around trying to get new information, trying to stay up to speed with what's going on. You're keeping a lookout on the street for when MSP shows up. You're going to Lank's house. All that stuff. We'll get more information tomorrow. It's because you're keeping tabs on it and you're using your backdoor communication methods. Seems logical. How else would you know that that they're even looking at her? How would you even know that? If she takes a plea, it ends. If not, what is it? There's an episode. There'll be an episode, something like that. There will be an event. There's a reason why the defense brought that one out. Stephen Woolery, source code tells you exactly how and why data is recorded. She tripped him up by conflating how the tools describe what was recorded. Punked him. Did she, or did he just rest on nobody who understands her testimony enough to be following it? And the details of her reasoning and her conclusions and stuff like that. If you're able to follow her testimony well enough, her answer that the Apple source code is not the best source of information about how the iPhone works, it's facially ridiculous. It's absurd. It speaks for itself as being nonsense. By the way, that's not what Whiffen said. Whiffen acknowledged, yes, that would be the best. That would be the best, but it's not available. We don't have it, so we can't do that. So I think that was just enough for his purpose. Maybe she tripped him up. Maybe he was just, satisfied. Look, this is ridiculous. That's not what Whiffen said. It seems pretty ridiculous. Z, Google employee expert on defense witness list. I think they did last time too, though. I think they did last time too. And I'm not sure we ever knew what that was about. Z, Commonwealth witness have facial expressions of Dr. Spiegel. Well, hey, if another person is calling it out, maybe it's closer than I was giving it credit for. I don't think it was that bad. I mean, I never saw anything that was that bad, but I do have to acknowledge I'm looking down, taking my notes a lot. So not necessarily catching every expression on her face. I definitely saw there was like one point, eyes got real narrow. It was after he proved she was wrong. She's mad, big mad. Eyes narrow, trying to figure out where he's going. He's very suspicious, trying to get out ahead of him so she can cut in and interrupt him before he even finishes answering his question. I caught that, but that's definitely not Dr. Spiegel. Dr. Spiegel was not really a think ahead type. Not the impression I got anyway. Stevie Marie, need to know, wasn't her EST UTC conversion wrong? Hey, also the second person to bring this up. Yeah, I don't know. She didn't get crossed on it. It occurred to me it might be a discrepancy between standard time and daylight savings time, because that would be reflected in the display, right? If it's January, it's in daylight savings time. It should be that's what should be displayed on the phone. So it should be that. Is that the difference? I don't know. I'm trying to think out in my head. Okay, spring forward. So during standard, it's 6 o'clock. Daylight savings at 7. Is she just converting it back to standard when it's supposed to be daylight? I don't know, guys. I don't know. I mean, can probably find out on Google. We can probably figure out what the conversion is. She didn't get crossed on it. I don't have an explanation for that. Zeke Tex NP, mainstream media reporting this witness tore apart the defense's timeline. Hope the jury isn't seeing it this way. We know she's full of it. Hope the jury does. I don't know where they get that. I don't know where they get the tore apart the defense's timeline. She testified about the 227 Google search. Her opinion is the search happened at 6:24, but she can't say what happened in the tab before that. If you listen to her testimony and understood it, that's what it was. I don't see that tearing apart anything, and certainly not the timeline as a whole. Lori Feeney is a new member. Welcome, Lori. Appreciate having you on the channel. Feeney, good Irish name, isn't it? Welcome. Z, Bev complain about own rulings, no grounds equals sidebar. Hey, if you need to have a sidebar, you need to have a sidebar. Let's not comment to the jury about it at all. How about that? Because we're all just doing our job. We don't care if you're internally frustrated. You're just not supposed to express that. That's part of having decorum in the courtroom that you expect other people to also practice. Emotional lemonade. My dog literally just woke up and walked over to TV when Andrea did the up voice hypothesis proven. It's how you talk to puppies. Hi, puppy. All right. That's what people do. Hi, baby. I'm friendly. I'm talking in the high-pitched, unthreatening voice, because if I talk in my low voice, you might think I'm growling and aggressive. Thanks for that little piece of I don't know if that's technically data. It's probably an anecdote, but we could do it like 100 times, and now it's data. Rob Inson, if you don't know your error, you haven't made a measurement. In my first physics class at uni. I love that expression. I've never heard that one before, but I like it. Yes, it makes sense. That's science. You understand how certain you can be about any particular proposition. That's the nature of it being scientific. SM, how to hide a modified PDF, print and scan. Maybe. Yeah, it could be. You don't provide the original PDF with the metadata. You just provide a printed copy. I do remember that being an issue in some of the pretrial motions. The defense is complaining all we have is this printout of a PDF, and that's how this is supposed to be authenticated. Possibly. Don't know the answer to that. Green Pulp, why don't use Ghidra to disassemble Safari? I have no idea. Sounds like you know much more about the possibilities with whatever Ghidra is than I do. Didn't come up in Cross. Perhaps a defense expert will deal with it. I don't know. I'd love to be able to answer this for you, but I can't. If you want to share more about how this would work, we'd love to hear it. My Mini 67 butt dials is third-party tool, Hank's new nickname. I like it. Third-party tool is Hank's new nickname, or perhaps it's Hank's mom's boyfriend. I don't know. God, I said I was going to stop doing that yesterday, but Darcy Dutz, it's raining men, fight scenes in Bridget Jones' diary. I forgot about that. It's raining men. It's just, is it like it's such a funny joke? You got to bring it up at every family gathering over and over again. It's not, is it that funny? I don't know. I guess I don't get the reference. Summertime with evidence I've seen. I don't know how Karen was indicted. Well, This evidence is not necessarily what they presented to the grand jury because, of course, they presented their cherry-picked best stuff, best version, completely unchallenged, untested by the defense. So imagine, leave out all the bad stuff and just give the good stuff. Just give the stuff that the Commonwealth thinks is helpful. Just give that to the grand jury. That's how. That's how they get it done. They don't bring up the bad stuff. Michelle, is it odd the defense pushed Keefe to say he saw the medical examiner looked at John O'Keefe? Do you think that will come up later, or is it a question that makes the witness look dumb if they don't answer? So let me get back to that line of questioning with Connor Keefe, because really what that was emphasizing was her conclusion that the cause of death was undetermined. And of course, that isn't in evidence yet, which is, I think, why that was being objected to and sustained. So they were trying to get into what we heard about from the last trial, which is that the Norfolk County District Attorney's Office shares their theory of the case with the medical examiner. And it's part of what the medical examiner does is consider the extrinsic facts and circumstances of the death, besides just what she can see herself from the autopsy. And she uses all of that information to make her determination about cause and manner of death. And so kind of the way it fleshed out in the last trial and the impression we got is that, yeah, Buchanan and Proctor are communicating their theory to her, and she, medically can't corroborate it. So she reached a conclusion of undetermined. That's what they're trying to get at. They were suggesting, did you communicate your theory with her? Did you, understand? All he said was he didn't provide a theory. He didn't provide a theory to her. So, doesn't know if Proctor spoke to her. That was sustained. That's really what they were getting into. He's not really the best witness for that, I guess. Because he isn't the one, at least that we learned of from last trial, called her a whack job cunt. Whack job C word. Whack job. After she rejected their theory of the case. Communications between Proctor and Buchanan about go try again, go tell her more, go try to get her to change it. I don't even remember what the exact words were, but just the impression we got from him. Oh, you're going to go try to lean on the medical examiner a little bit more and get her to change it to homicide. And ultimately she never did. So instead they were just getting into, okay, he's there present at the autopsy. So you saw all these injuries, right? And, so that he can validate that her conclusions were based on those things that he saw. It's really what the defense is trying to accomplish. It's a little bit backdoor. It's probably not proper. They're just previewing, what the evidence is going to be, but not really for him to say what Squirty Bello saw or didn't see, knew or didn't know, concluded or didn't conclude. That's for her. But pointing out, well, you saw the marks on his arm, right? His arm wasn't hidden. It was right there. It kind of speaks to why wouldn't we want the jury to know what his injuries are? Like, why would we be fighting getting information out? Like, of course she looked at them. She's doing the autopsy. She's the medical person. You're not, but you could see them. So of course she saw them and took those into account. Like, what a ridiculous thing to object to. It just served to kind of make it look like, why would there be a problem with any of this? So I think they were trying to achieve something that was not really proper with this particular witness. But it gave them that opportunity to be like, nice objection, dumbass. That's my read on it. All right, guys. Day 11 in the books. Day 11 in the books. Still not proven John O'Keefe was hit by a car. Nope. Nope. We got a little bit closer because we were talking about that autopsy and those injuries with Connor Keefe, but no, the Commonwealth was objected quite strenuously to that. They don't want us to know about John's injuries. Not quite yet. It's not time for that yet. Not time for the undetermined cause of death conclusion or manner of death conclusion. So instead, just some taillight, with some taillight issues. Extra piece there in the bag. Don't mind that. Just take it out and admit the rest into evidence. What a circus. What an absolute clown show. I mean, it's ridiculous. What's it doing in there? Nobody knows. How did it get there? Nobody knows that either. Did it just break off? I don't know. Nobody showed me. And so far, that other little piece, it's not in evidence. It's marked for identification. It's not in evidence until somebody comes and claims it as a piece that they recovered and booked into evidence. I don't think it's coming in. That's the whole problem. They don't have a chain of custody for that piece. It's not the one he collected and put in the bag. So nobody has claimed it. Somebody going to come in and claim it? And will that look even more ridiculous if they do? Oh, that's mine. Well, then how did it end up in this other bag? Where bag? Why is it not in your bag? Yeah. More taillight. And then Jessica Hyde doesn't know how the 227 timestamp is created. What a day for the Commonwealth. What a week it's been so far. Here on our hump day. Now done. We're on the downhill slide towards the end of the week. We're on track, guys. Maybe even a little bit ahead of schedule. And still waiting very patiently for proof that John O'Keefe was hit by a car. Just like last time. Just like last time. And so far, the only advantage that Mr. Brennan has, still kicking the can down to the very end of the road. But at least he hasn't called every single redundant, unnecessary witness to the stand first. Here we are going into day 12. Going into day 12 tomorrow. Maybe day 12 will be the day. It's not day 23 or 26 or I don't even remember what it was with Mr. Lally, but it was 20 something, multiple days in before we started to get into any sort of evidence, any sort of theory that John O'Keefe was hit by a car. And it's pretty fundamental fact to the case. Yeah, all of this is not giving me confidence that the Commonwealth has cured the fundamental issues with their proof that prevented them from getting a conviction the first time around. Because the most significant failing there, you have a real hard time proving John O'Keefe was hit by a car. That's what Ronnie, the juror, told us. Everybody on the jury with a medical background was like, yeah, those injuries don't work. Those don't work. I don't know how you overcome that problem. I really don't. Not seeing anything so far that gives me confidence that they have. Because if you have that strong of a case he was hit by a car, don't you lead with that? Get that established first. Then we don't have to argue about Google searches. If we can at least establish he was hit by a car, then we can narrow the possible scenarios that would have led to that. Could have been Karen at 12:30. Could have been hit by a plow, whatever. A little bit harder for Karen to get out of if we at least establish the predicate fact that John O'Keefe was hit and killed by a car. We're still not there. And just from the kind of ordinary standpoint of how cases are typically structured, the autopsy and that part of the investigation is typically an early part of the investigation. So I'm generally pretty accustomed to hearing about it pretty early in the case, because you talk about, okay, here's what we know about how the guy died, and then we go and turn to proving this is the person that caused that, and here's how. It's just a kind of logical way to think about it and to present it. You know, we had the autopsy. The injury was a, dissected aorta, had all these other injuries. What can cause that type of injury? Car accident. Then we go in and we present the proof that this person was driving the car that the decedent was in when they had a major car accident. And then we go in and prove they were intoxicated. It's just a kind of logical, easy to follow way of structuring the case. Definitely not doing that here. Wouldn't that make a lot more sense? Let's establish John was hit by a car, and then we can narrow the field and prove that it was Karen's car that hit him. But we're not doing that. We're not doing that. There is a reason why. Well, guys, thank you all for being here with me again. Another day down in the trial of Karen Reed. Yeah, I have a little note here to double check. I'll see if I can do that before we come back tomorrow. The consent was signed by Jen McCabe on February the 12th at 12 p.m. or February the 2nd at 12 p.m. Is there activity on her phone that we know of after that time? I'll go back and look through and see. I think particularly the group chat was what was called out. Was she group chatting after that? I don't know. I'll have to go double check. We'll see. We'll see. But otherwise, guys, didn't get up as much today to move around. I did a little bit, but not as much as yesterday. I am starting to feel it. It's time to get up and move, guys. Time to get up and move. Get some activity, get the blood flowing, get the energy up, get the muscles firing, the whole neuromuscular activity, get it fired up. Good for all of us to do that. So I'm going to go ahead and take the opportunity to do that now. Appreciate all of you being here. Thank you again, as always, to the mods, giving us such a great chat, such a good environment. And thank you to all of you who can contribute. Thank you to all of you who have supported the channel. Really appreciate each and every one of you. And we'll be back for more tomorrow. See what we get. Is tomorrow going to be the day they prove John O'Keefe was hit and killed by a car? Well, we'll find out then, won't we? All right, guys. Everybody, take care of yourselves. Be good to yourselves. Be good to each other. And I will see you when we get back tomorrow.